The recording. Welcome everyone to day 2 of hearing 23A, dealing with maps and definitions. Before we get underway with everything, Antoine, could you start us off, please?
You're happy to. He mihi kawana kia koutou, ko tai mai nei tēnei rā, ki te whakawhiriwhiringa kōrua e pāna, ki te mahere rohe o ngā motu, o tira he mihi kawana ki ngā kārangarangatanga kei wainga nui a koutou. Kia koutou ngā waka, ngā iwi, ngā hapu, ngā tangata, ko tai mai nei tēnei rā, tēnā koutou, he mihi kawana. I tīmata i tātou wāhanga, I mua e tātou karakia. Ko te pū, ko te more, ko te weau, ko te aka, ko te rea, ko te wā nui, ko te kune, ko te whē, ko te kore, ko te pō. Ko te pō nui, ko te pō roa, ko te pō uri uri, ko te pō tango ki te whai au ki te ao marama. Ka rongo te pō, ka rongo te ao, tui a te kāwai tangata e hiki mai Hawaiki nui, Hawaiki roa, Hawaiki pāmamau, I hono ki te wairua ki te whai au ki te ao marama. Ti hei mauri ora, tūturu o whakamaua kia tīna, haungi hui e tai ki e.
Kia ora.
Kia ora everybody, and apologies for the cat. Once he heard me doing karaki, he wanted to join in, but didn't know the words.
Thank you very much, Antoine. Yes, so I'm looking around who's here, and I think everyone's appeared before us before, and really I don't think I need to go through the general introductions as we normally do. So unless anyone's got some questions on process or anything, or does anyone have any questions or matters to start the day with? Okay, it looks like we're all okay. So Peter and Andrea, I think you're first off the...
Oh, Mr. Chair, it was a matter that raised on Friday morning, just in regards to potential conflict of interest, which I've registered on our previously before we started our hearings last year, and that's that I'm working with Department of Corrections on the Whanganui Prison, and obviously Mr. Hall and Ms. Miller are here with us today, and I work quite closely on that project. It's in another district, but it is Department of Corrections related, and obviously they've come here today. So it was a matter I raised last week, and I think from memory, our discussion was we'd raise it again this morning, see if there are any issues for the submitters, and then we'll carry on from there.
Yes, Antoine, I think you've declared that potential conflict of interest in our schedule, so we haven't heard any issues back on that. So unless anyone would like to raise something now, just in terms of Antoine hearing these matters. No, it sounds like we're all good to go. So all right, welcome Peter and Andrea, we're in your hands.
Kia ora koutou. Peter Hall, planning consultant on behalf of Department of Corrections Arapōtama. I'm joined today by Andrea Miller, who's the manager, resource management and land management from Arapōtama, who's able to answer any questions that should arise. The two aspects of the department's submissions on definitions relate to a definition of community corrections activities and its inclusion in the plan. It is included, but how it's included in the plan was the point of the submission. And the second one relates to seeks a new definition of households, or household be included in the plan. So council officers have agreed with both submission points in the 42A report. The first point, just dealing with community corrections activities, the department's submission effectively sought that community corrections activities fall in the same zones as community facilities. And what I mean by that is where they are permitted in certain zones, and where I should say community facilities are permitted, then community corrections activities are permitted. And those, of course, are the community corrections activities are the non-custodial aspects of the department's work in the community. I think I've talked about that at previous hearings as to what that entails. Effectively, the submission sought that community corrections activities be provided for in the same zones as community facilities. Where they're permitted. Where they're restricted discretionary, they're the same, and where the discretion non-complying, they're the same activity status. And I suppose the planning logic of that being that, in essence, they are a facility that provides for reaches into communities by its nature, and provides for has a similar range of effects as typical community facilities. So the officers have agreed with that position. You might have seen the initial 42A report recommended that the definition of community facilities be amended to simply include the community corrections activities, which was one of the reliefs sought by the department submission. At the end of last week, I saw a correction to that position come through, which I also agree with and support. And there's another way of achieving the very same thing, and that's including a nesting table for community facilities. I think the original recommendation said community activities. That's just officers might clarify that it's supposed to be community facilities as the new nesting table, and within that we have community corrections activities and emergency services facilities. So in other words, just to emphasise that key point again, wherever community facilities appear in the district plans, and as a subset to that, so do community corrections activities, those non-custodial operations. So the definition of community corrections activities stays otherwise the same. So that's we can confirm we're happy with officers' recommendations on that, to include a nesting table in that way, and it aligns with the relief. Equally, I can confirm support for the inclusion of the definition of household in the district plan. The plan follows the National Planning Standards approach and has a definition of residential unit, which refers to household. And household at the moment isn't otherwise defined. It's our experience that it is useful to have a definition of household to ensure that plan users and plan readers understand it's not just residential unit, is not just your typical family situation, and in modern situation includes supported residential care. And so that's an area where the department has a particular interest, because it provides for those facilities throughout the country, and as do other service providers. And so the definition of household, as recommended to be included, is supported by us, and includes includes members, whether or not they're members of the same family, but one or more members of the group, provides day-to-day care, supported supervision to any other members of the group. So the Aratapatama provides residential units in the community throughout New Zealand, and there's a range of housing, rehabilitation and reintegration services provided in these facilities. People living in those are not detained on site. They're free to come and go into the community, the same as anyone else living in the community. However, they would have particular support needs after they leave custodial care. So the definition as proposed to be included for household covers that particular aspect well. And I think from a planning perspective removes any doubt as to what a residential unit is. So again, confirm support for the 42A recommendation in that respect. Probably just lastly to point out the strategic objective 15, urban form and development, is that a variety of housing types, sizes and tenures are available across the district to provide for the community's diverse social and economic housing needs. So I think, again, this recommendation picks up and follows logically that strategic objective in the plan. That's a brief summary of to confirm the support for the 42A officer's position, so subject to that revision around the community facilities nesting table. So I'm happy to answer any questions.
Thank you, Peter. Antoine, do you have any questions?
I just had one minor point, perhaps. It's just in regards to the definition for household, which has been recommended to us. And I just wondered, just in your experience, and I'm just looking specifically at the one or more members of the group, whether or not they're paid, provides for day-to-day care, supports, supervision, and to any other members of the group. And I just wondered whether you had any experience of any unintended consequences as a result of that, because obviously in terms of your client, that resolves the issue for you, but just wondered whether that particular definition includes other things that we might not have otherwise intended from your experience.
No, not from my experience. I think that this definition picks up anyone from a situation where there might be a nanny providing support services. There might be a daily service provider providing health or daily care sort of facilities, and all the way to more of a supervision type of role within the facility. And I think all that whole scope, I think, is necessary to pick up this these sort of situations. I think what I have experienced is the opposite, where there might be a question raised as to whether this service provider is in fact providing some sort of occupation, and that therefore turns into more of a commercial or home occupation type of situation. And so
that's sort of where I was going. But we've got some quite specific definitions elsewhere that probably cover that, I think. Yeah, thank you.
Yeah, thank you.
Kit, do you have any questions?
Yeah, I was just interested, Peter, sort of trying to get a sense of the relationship between the two different amendments that you're supporting. And I guess the question can be best put like this: when does a community corrections activity stop and a household begin? Because at the moment we've got a nesting table which is proposed to now include community corrections activity, which, as you've defined, means the use of land for non-custodial services within community facilities. Community facilities then have different degrees of permission to some extent, which you talk about in 5.8. So we've got this hierarchy, or this permitted, dis or dis, and then non-complying for community facilities, which includes these community corrections activities, which is all well and good. But by amplifying or clarifying the definition of household, though, does that then make a community corrections activity, which for all intents and purposes, your evidence is that it is exactly the same as a household, permitted within all of the residential zones? Is that the intention of the change or the clarification of the definition of household? Are these the same thing, just called different things?
No, not at all. And I think the key and absolute essential difference is that one is residential, and one is definitely a residential facility. So it's a place where people live, commune, kitchen facilities, sleep, all of those aspects. So that fairly and squarely falls within the definition of residential activity. The other is fairly and squarely within the definition of a community facility, which is a place as we know it, which provides a service to the community, a place to work, employment, and as a service function back in.
So the distinction is that any land or buildings that might be being utilised for community corrections activity would not, by definition, extend to allowing those land and buildings to be used as a household.
Absolutely. And so I think they're very distinct definitions, and they sit distinctly in the plan as definitions, distinct definitions. So anyone reading one would say, well, you're not this, you're the other.
Okay. No, I think just following the wording through right to the end, I can see the distinction now. Yeah, okay.
Thank you.
If I could just jump in, Commissioner.
Sure.
Other districts have addressed that distinction by putting a limit on the hours of operation for the community corrections facilities.
Okay.
So comes kind of, you can be open from 6:30 till 7 p.m, for example, and that precludes anyone overnighting there.
Under this plan, Peter, remind me, are there any standards for the zones in which community facilities are permitted that have any constraints around hours of use, or would it just be around the general effect standards that would apply?
Not to my knowledge, it's just the general effects standards that
Yeah,
apply. You might recall that we had a bit of a discussion on that in the industrial zone,
Yeah,
but it was not so much hours there, it was about the size and scale.
Yeah, okay. So in those zones where you might say that the zone is slightly more sensitive, like your residential, though, it would require a resource consent, and then in that process you might have the potential to put hours on it. Okay.
Yeah, well, that's exactly right. You require
Okay.
discretionary resource consent, and one of the matters of assessment is those type of matters for community corrections activities. You know, as distinct from a residential activity, which clearly belongs in that zone.
Yeah, yeah. No, that's helpful, and I do think, I mean, it's interesting that the proposal you're putting forward and the council are putting forward for a change to the concept of a household really is as a sign of the times, isn't it? There's this traditional parochial view that a household is a nuclear family, but of course that's just not the case anymore. And there are lots of situations where, you know, people live together and they get care provided for them by a full-time care provider, and yet we find that as perfectly acceptable within a residential context. So I think you're right to be breaking down these sort of distinctions. They don't really have an effects basis. So I appreciate that.
That's certainly how I've made that described in my evidence. Simply they are modern living arrangements, which you know, are far and different and more complex and nuanced than a traditional nuclear family that mum, dad, and the kids that go to work every day.
Yep.
You know, many households have the need for daily care of all sorts of different ranges, and including supervision for that purposes. And so I think that's picking up on that. Yes, that's exactly right.
Well, that's excellent. No further questions from me. Thanks.
Thank you, Peter. I picked up that you were seeking a clarification from staff about one of the matters. Is that right, in terms of community facilities versus community activities?
That's correct. It was just the last amendment to the 42A report used the term community activities in the nesting table. It was not a term which is actually used in the plan. So my suggestion was simply to change that to community facilities. This was a Friday exchange. So I think I understand staff are happy to do that.
Jamie,
yes, I can respond to that. So Denise is the reporting officer for the corrections.
Yes, that's right.
Yes, but on Friday we did issue a corrected addendum that referred to community facilities instead of community activities. So that has been corrected now.
Thank you. And I have no further questions. Just like to say we appreciate your attendance, and certainly even though you're supporting the council staff, actually coming and giving us a chance to ask some questions on this, you know, pretty important area is very much appreciated. Thank you for your time, and have a good rest of your day.
Thank you,
Thank
sir.
you.
Thank you, commissioners.
Bye-bye. Right, Helen Johnson. Good morning, Helen.
Good morning, commissioners. So thank you for the opportunity to speak to the panel this morning. In general, I have agreed with the recommendations of the Section 42A reporting planners. There's only one matter which I would like to speak to the panel about, and that relates to Esplanade Reserves, Esplanade strips. And I appreciate that this is a matter that has gone across quite a number of the hearings. It was discussed in hearing 5, it's come up in hearing 9, and now I'm raising it again in this particular hearing. But so I guess it's an evolving situation over those hearings. And there was just one matter that I felt that hadn't really been addressed through the previous hearings, and that relates to the requirement for esplanades within urban areas. In my evidence, I refer to the fact that in the operative district plan, it was clearly identified where those esplanades would be required, and also type of esplanade would be required, whether it was a reserve or an esplanade strip. The proposed district plan takes a slightly different approach in that that type of esplanade is reserved to the council to determine at the time of the application. And as I noted in my evidence to the submission here, to the subdivision hearing, that can make life a weeny bit difficult because you don't know whether you are going to have to set aside an esplanade reserve, and therefore that area can't be taken into account when you're designing the layout and the size of the allotments, or whether you're going to be having an esplanade strip, in which case that area is not taken out of your lot size. So the reason I understand Ms. Gulliver's recommendation with regard to it, because from the written right of reply that Ms. Lawrenson did for the subdivision hearing, she didn't recommend any changes, and therefore Ms. Gulliver recommends no changes to the planning maps. I guess where I have a little bit of an issue of concern was that I didn't feel that the right of reply actually addressed why they've taken this approach, particularly given that in the ODP, the urban areas have quite a network identified, particularly through the access strips or the access areas that are identified in it. When we were putting together the operative district plan, the parks team were quite heavily involved, and they identified the network based on reserves plans and long-term planning. And so that provided, I guess, a level of certainty as to where those areas were and how they would be provided for, which I don't really feel that the proposed district plan does address. So from my perspective, I would appreciate it if in the written right of reply, the commissioners would allow perhaps that aspect of my submission to be incorporated into the right of reply from the planners. So that's really all I had to raise with you today. Thank you.
Thank you. So we had a similar issue with some of the water definitions on Friday, Helen. It has been considered that those matters had been considered in the previous hearings, but there was some further evidence from Federated Farmers on those matters. And in that regard, we were happy not necessarily to have the matter relitigated, but just for it to be thought about again with some further thoughts. So I think this is the same situation where this hearing does raise the same issue that was being discussed before with previous 42A reporters. So look, we'll see if there's any questions, and then we'll ask Ashley whether she's got any initial feedback. So starting with you, Antoine.
I didn't have any further questions.
Thank you.
Chair.
Kit, did you have anything?
Yeah, I was just, I had a bit of deja vu reading your evidence, and I realised it was because this was an issue I was discussing last week, really. And I think the conversation went along the lines with the planners. So who gets to determine whether it's a strip or a reserve? And you have said in your evidence at 21 that it's your view that there is within these provisions a reservation of discretion on the type of esplanade that would apply. And I guess I had sort of initially read it that because it was non-specific, there was no discretion to the council. An applicant could effectively say, well, I'm only giving an esplanade strip. A strip complies with the standard because you've not been specific, therefore that's all you're getting. So there's an interesting issue there. The other concern I had was, and I think when I discussed it with staff, we were scratching our heads as to whether there was any way we could actually cure that. And what you've helpfully done is reminded me that you've raised this point already. So there is scope to be very specific about the circumstances where a strip would be required versus when a reserve would be required, because your submission's been quite clear that strips should be within the rural zones, but reserves should be within the urban zones. So that solves one bit of the problem, that there is some scope to address this issue. And then I think all we need now is for the council to give us a bit more of a little bit of a response on whether they think that that's the appropriate way to sort out this ambiguity about when and who gets the right to say whether it's a strip or a reserve.
That's a really interesting point, Commissioner. It's yeah, I'd come at it, I guess, from one perspective, and it's interesting to get the alternative. And I guess, as Commissioner Daish said, this has been talked about before, but because Ms. Lawrenson reserved it to a right of reply, I didn't have an indication of where it was going to go. And I guess the other point is that in urban areas, the type of access you're providing is quite different. It's more focused, it's more integrative, as opposed to what we saw as, I guess, mountain to sea connection through rural areas, and the fact that in the Taranaki region, they do tend to move. And one of the big issues that we had at the time was that we had landlocked, I mean, not even next to streams, we had landlocked reserves that we couldn't do anything with. And so that was, I guess, why I wanted to get that, apart from the issue of providing certainty for developers, that issue addressed. So I appreciate your comments.
The other point I just wanted to talk about was you're saying about esplanade access requirements in urban areas where lot sizes are smaller. Now, of course, the way the esplanade reserve provisions are set up in the Act is that there's no right to compensation if you are subdividing a parcel of land that creates the first title that's less than 4 hectares. You've effectively got to give that up. If, however, you've already got a parcel of land that's less than 4 hectares in area, and presumably that's what we're going to find in the urban environment, but for whatever reason, historically, no reserve has been taken, in those situations, as I understand it, the council can still identify that it wants a reserve, but it's got to pay compensation for it. Is that your understanding of how it works?
Gosh, that's a hard question for a Monday morning.
Okay.
I'd have to go back to the Act and give that some thought, Commissioner.
Yeah. Look at yeah, it's not a fair question really, because there's some nuances of legality in the Act. You then get the other situation which I've come across where, for whatever reason, an old esplanade reserve was taken under the old Counties Act and it was only 10 metres wide. And then for whatever reason, the parcel of land, and it's happened actually quite a lot up through the Tamaki River, right up through the edges there, up into the isthmus, where industrial sites are redeveloping and doing a boundary adjustment, and the council comes along and says, well, we want a top up now. We're entitled, and I think it's section 336 or 236, to actually ask now for an additional 10 metres width. And I've seen that happen a couple of times. So there's some nuances in these provisions that I think we've just got to get our heads around, really, because it does have an implication for council if they're taking reserves in circumstances where there's not an obligation initially just to vest that in the council. So, all right. I don't need you to answer that. That's for me to sort of wrap my head around and to work out, really. But no, I agree. It's a point we need to sort of get our ducks in a row on. But thanks, Helen. That's good.
Thank you.
Ashley, I presume you've been listening in. Is there any initial response while we've got Helen online to talk anything through with?
Yeah, can you see me all right?
Yeah.
Yeah, so that was helpful to listen to that discussion, but I'd also like to talk to Denise Young about all of that, just to make sure it is all aligned with that. So nothing at this point, but yeah, I would like to address that in the verbal and written replies.
Okay. Thank you, Ashley. And as always, Helen, thank you very much. I don't have any further questions. I think the issue's on the table. And I said on Friday that I thought it was quite useful to have this interim opportunity to look at some of these these more detailed matters in this hearing and before the sweep up. So there's an opportunity just to have another look at things. It's not a normal process. You can come back and have another bite, but sometimes it's sort of worth pursuing some of these more technical matters. And so thanks, and we'll see you next time probably, or maybe. Thank you very much, Helen.
Thank you.
All right, so we're now moving to Nicola Hine. Nicola, you're online.
Yes, I am.
Yes, hello there.
Good morning.
And thank you for your evidence. We did get that on Friday.
Correct.
And we have read it through, but I think, I'm not sure whether you were listening in on Friday. I don't think you were, but we did. We have had quite a lot of evidence on this matter from the staff, and now we've got, certainly Mr. Woods gave us some evidence prior, and now we've got your statement. So we just really, it's a little bit of a head scratcher, I have to say. So we'll see if we can actually, just with your assistance, understand the issue clearly, and we'll have a good discussion about it. Thank you.
Yeah, I wasn't sure if I was to take my evidence as read.
Yes, it is. Do take it as read, but we do want you to give us, pick out the highlights and yeah.
Yes. Okay. I'll do what I can, because it is a head scratch and it took me some time to go through and understand the implications as well. So I do want to start and say thank you for NPDC Planning and Commissioners allowing me to present this morning. I do appreciate that. I guess in summary, the first guest agree with the intention of the recommendations. I think there is some alignment there with the recommendations contained within the Section 42A mapping report. However, I think there is discrepancy, perhaps confusion with regard to the referral to compressor stations specifically, when I believe the intention may have been to include above ground sites. So I don't know if, and I believe it stems from the Network Utilities right of reply. There was some sort of reference to above ground sites, but then also compressor stations, and contained within those recommendations in that report was referral to compression stations specifically with regard to the 30 metres setback. Now, we only have one compressor station within the New Plymouth district, and the reference, for example, I think the most telling paragraph, if you like, was 47, in that it sets out the recommendations within that Network Utilities right of reply report, which states that if the panel is satisfied that there is scope within first gas submission to measure the setbacks from above ground assets, specifically the delivery and receipt of points and mainline valve stations, the gas transmission pipeline corridor extent could be amended to planning maps to ensure it is a 20-metre distance from the pipelines and identified above ground assets. Now, the footnote there is number 18, and it states, because the compressor stations were clearly identified in figure 1.1 of the original submission and clearly included in the scope of the original submission. So there was that scope aspect as well. And then further in paragraph 47 there's the definition of the gas transmission pipeline corridor to include the area of land within 20 metres of the centre line of the gas transmission pipelines and ancillary above ground structures, except for compressor stations, as identified on the planning maps, and then to go on to the 30-metre setback from the legal boundary of the compressor station site, as identified as separately on planning maps as, again, gas transmission station corridor. And then there's a definition there which specifically refers to compressor station sites. And the corresponding footnote there at 19 refers again to that figure 1.1 of the original submission. So I believe that from that report, the compressor station has been sort of separately identified, but incorrectly referred to as the maps that were included in that figure 1.1, which weren't compressor stations. They were a variety of above ground sites. So on the basis of that, I think our intentions are aligned, but the wording is possibly, is incorrect. And that is why I've suggested that the amendments are made to reflect that we have more above ground sites than just the compressor station. I believe it's in keeping with those recommendations, which have followed through to the Section 42A mapping report. And so in my, I guess, we would support some slight changes to the recommendations, which, and I refer to 35 here in my, evidence, that we retain the extent of the gas transmission pipeline corridor to 20 metres either side of the pipeline. However, then add the new layer called gas transmission station corridor. So that is the location of the above ground sites identified with a 30-metre buffer. So it's not just limited to that one compressor station. And further, we have confirmed that the GIS shapefiles we have supplied are the sort of official source of our network, if you like. So that was another matter that was brought up in the utilities chapter. Hopefully that sort of tries to explain where I think there's been some confusion. It does stem from that first right of reply.
Yes, and Nicola, Kit and Antoine weren't on the utilities hearing. That was one, as I recall it, that Commissioner McMahon and I heard. So this is linked to that. I wonder, before we take questions, whether, Ashley, this is your report, I think, is the mapping issue.
Yes.
Yeah, and Jamie, I saw you were online as well. So you were the 42A report for the
Yes.
utility. So maybe between Jamie, you and Ashley, you could give us an initial sort of rundown of where you're up to with this issue and the extra evidence that Nicola's provided.
Yeah, so possibly best for me to just give some context and kind of the background to this issue for the benefit of the other commissioners that weren't part of the Network Utilities hearing. And kind of speak to what Nicola has just said as well. So yes, I was the reporting officer for Network Utilities, and just by way of background, the proposed district plan included a gas transmission pipeline corridor, which was a 20-metre distance from the pipeline, and the purpose of it is to protect that high pressure gas transmission pipeline corridor from certain activities like earthworks and sensitive activities within that pipeline corridor. So it's a new approach that was carried through that was introduced in the proposed district plan. It was not included in the operative plan. And initially it was focused on the pipeline network rather than the above ground infrastructure. But it came through in First Gas's submissions that the above ground infrastructure should also be protected from potential reverse sensitivity effects and protect sensitive activities from health and safety effects of the gas transmission pipeline corridor. So initially First Gas made requests to have 30-metre and 60-metre setbacks and associated rules for sensitive activities and gas transmission sensitive activities from their above ground assets. And their what Nicola has referred to as a figure 1.1 of First Gas's original submission. Is it okay if I just share my screen to show the cool. So hopefully you can see it. Oh, here we go. Can you see my screen now?
Yes.
Yes. So this is the original submission from First Gas, which showed the above ground assets in the New Plymouth district. So the orange dots are referred to as station sites in the legend, in brackets above ground assets. And in general, First Gas's submissions sought greater protection for the gas transmission network. So it was quite broad in terms of the scope. It was seeking protection for. And then in supplementary evidence that we received from Zane Wood in the Network Utilities hearing, there was a correction by First Gas, which showed that the above ground assets in the district are actually much more significant than what was originally outlined in their submission. So the scale of this image is not great, but you can see all the orange dots and all the pink, all the orange dots with names across the New Plymouth district are the above ground assets, including stations. So we don't have specific details at the moment on the number of stations and the breakdown of different types of stations that there are. But at that hearing, First Gas provided evidence on what the nature of those station sites are. So they explained what a compressor station site is, what a mainline valve station site is, with photos of examples, and then examples of the delivery points and receiver points, which are the smaller scale kind of above ground assets where there might be a pipe that kind of sticks out above the ground with a valve, not a huge kind of piece of infrastructure like the compressor station and mainline valve stations typically would be, based on what was said at that hearing. So we went away from that hearing and considered the requests, and there was a question of scope as to whether First Gas did have scope to map those above ground assets and the setbacks, given that all of the above ground assets weren't originally identified in their submission. So the legal advice we received from Simpson Grierson was that when you read the submission as a whole, there is scope for broader protection of the First Gas transmission network, including above ground assets, because they sought a new definition of gas transmission network, which included above ground assets. But it gets slightly more problematic when you're looking at the scope to map the above ground assets and the setbacks, because all of the assets weren't identified on that figure. So in my right of reply, I left it up to the panel with the benefits and costs of both options, and said if the panel did have, was comfortable that there was scope to map those above ground assets, I recommended that the gas transmission pipeline corridor was amended to make sure that the 20-metre distance was mapped from ancillary above ground structures, and then recommended a separate definition for gas transmission station corridor, which would be the 30-metre setback from the boundary of compressor station sites associated with gas transmission pipelines. And Nicola has correctly identified that I had assumed that the above ground these dots here were compressor station sites, all of them based on what was discussed at the Network Utilities hearing, where one of the First Gas representatives mentioned that there was a dozen or so compressor station sites in the district. So there was some confusion there. And I think we do need to go back and perhaps get some more information from First Gas on where exactly all of their station sites are, with maps at an accurate scale, and breakdown of what those above ground assets are, and then reconsider what the setback should be based on what information we have in front of us and the nature of those sites, and considering the adjacent land uses. So that's the general overview. If anyone has any questions, let me know.
Okay, Jamie or Ashley, the appendix 4 to the mapping report has a number of images showing 30 meters. Can you just join sorry to pardon the pun, but join the dots on what those are showing us?
Yes, so the appendix of the Network Utilities mapping that we did was to, so this may have been where a misunderstanding has occurred as well, because we don't have setbacks. It was just bringing those within the corridor itself. So we've taken the extent of those GIS shapefiles and made sure that they sit within the pipeline. So there may be a setback missing from those. That's correct, Jamie? Based
Yes.
on the discussion that kind of has come to light just up into this hearing.
Can we actually just bring one of them up on the screen? Maybe the first one, if that's a good example, just to explain.
I'll just share my screen now.
Oh, thanks, Jamie.
Yes.
So this is the Frankley Road offtake. So I guess based on the information that we have, this is not a compressor station site. So based on my initial recommendations, this would only be included within the gas transmission pipeline corridor. And instead of, so essentially the 20-metre setback from the site boundary, the yellow line would be extended to move to a 20-metre setback all around the site boundary to line up with this pipeline corridor here.
Okay, in the blue hatching,
I guess that becomes part of, that will be, or that is the site of the Frankley Road offtake. So the setback would be measured from the site boundary. So the 20-metre would come from the site boundary, but this would become part of the gas transmission pipeline corridor. But I guess what I'm saying is we need to have accurate information from First Gas on all of their above ground assets so that we can make an assessment of whether it is the most efficient approach to include these above ground sites as part of the gas transmission pipeline corridor, or whether we need to look at including additional sites within that gas transmission station corridor. For example, the is it receiver station? There's different types of above ground assets. Yeah, I originally thought the compressor station sites were the only ones that needed to have that 30-metre setback, but now it's been made clear that the main live valve stations and potentially offtake stations need to be considered as part of that as well.
Because we're dealing, Jamie, with the same sort of pressures and pipes and structures. The same issue applies to the infrastructure within these areas as they do in and around the pipelines from a management point of view. That's the point, isn't it?
Yes.
Yes. All right. And I think given that we have Simpson Grierson's advice that there is scope to certainly look at these things, the one issue is about the mapping and whether it could be reasonably understood by affected people that there may be buffers around some of these sites that might impinge third-party property rights. That's the test, isn't it, which we have to consider when making a determination on this. Look, I'll go to questions. It is a technical issue. It's mainly associated with the network utilities chapter, but obviously sounds like actually you and Jamie will work this through into the writer reply, but there's an information step you'd like to see as well. So perhaps before we go to questions, just on that further information, Nicola, I presume you're happy to liaise with Jamie and Ashley on information while they prepare their written writer reply?
Yes, we'll definitely do that. And we have supplied a GIS shapefile.
Okay, all right. So look, that's probably enough from me. I'll just see whether Antoine first and then Kit has any questions of clarification.
Thank you, Mr. Chair. I had two questions. The first one is, and just I don't think I was part of those initial discussions and so I'm just doing a little bit of catch up, but that was a really good summary to bring me up to speed on. Perhaps it's a bit of a naive question. Is there any statutory or legal requirement for the district plan to provide for corridors or setbacks for health and safety reasons and or reverse sensitivity requirements or matters?
It does come through in the regional policy statement. So protection of regionally significant infrastructure from incompatible activities. I think it's INF policy 1 of the regional policy statement. And there has been a fair bit of work done by First Gas justifying that these corridors and setbacks are appropriate for various reasons, including the health and safety effects of a pipeline failure, as well as potential effects on the integrity of the pipeline as a result of earthworks that may impact on the pipeline. So that's a lot of that detail is included in the Section 32 report, as well as the 42A report for network utilities.
Cool, thank you. The other question is, and I suppose it's the matter that our chair Stephen Daish has raised, just around whether submitters would have, or sorry, landowners would have reasonably expected that there would be a setback on their property of 20, 30 or 60 metres as a result of those submissions. And just it was quite good getting the roundup summary today, because it had the benefit of you've had the benefit of the other hearings. It seems in my mind that they may not have, because if they were specifically thinking about those compressor sites, and there's a range of other above ground ones, they may not have, and what impact that might have on providing for those.
Yeah,
this might be something you come back to and write a reply, but happy to hear any comments you might have.
Yeah, I guess just reiterating the previous advice from Simpson Grierson was that First Gas had, on the whole, they had sought greater protection of its gas transmission network, including above ground infrastructure. And I guess above ground infrastructure is visible. So a landowner who's immediately adjacent to that above ground infrastructure could possibly reasonably suspect that it applies to their land. But yeah, it is a questionable matter in terms of scope, especially because that figure one didn't specifically identify all above ground assets. So that is, yeah, I guess I'll refer back to the Network Utilities Writer reply, which covers the scope matter in a lot more detail, but happy to address any additional questions on scope if you have any of those.
No, that was my questions I had. One thing that does come to mind is, district plans in of themselves. Plans are instruments to try and resolve conflict between activities, rather than saying, drawing a black and white line, you're here and you're over there. The world doesn't unfortunately work like that. Perhaps it's shades of grey, and whether these submissions would actually provide for a process to resolve some of that conflict or actually create it. I'm not. That's just an open question for myself and my thinking. Thank you.
Thanks.
We've lost Stephen. I'll take the lead then. Just again, I wasn't involved in the Network Utilities chapter. Is the Simpson Grierson advice freely available? Has that been provided to the panel previously?
Yes, it was actually provided in email format, so it was an informal format, but it has been provided to Commissioner McMahon, so he's requested it and we've sent it through to him, and we've said if the panel wants to rely on it in a more formal matter, that we would need to instruct Simpson Grierson accordingly to put it in a more formal format.
Okay. Can you put that screen you were sharing back up, Jane?
Yeah.
I mean, as an example here, I'm just trying to get my head around the point of this overlay or this mapping. I mean, this is not about property rights, because presumably First Gas has got all of the necessary property rights to have all of this infrastructure below ground and above ground. It's all about telling the world that if they're going to do anything, then depending on where they're going to do it, they need to be wary of it for whatever reason. So it's really just an exercise, as Commissioner Coffin says, to try and avoid conflict. The yellow lines there, I mean, we've got this as pipeline corridor. What's the measurement? That looks like it's about what, 30, 40 meters across?
So there's a pipeline in the middle here, and then it's measured 20 meters either side of
Okay,
the
so that's-
pipelines.
so-
Sometimes
so-
there's 2 pipelines, so it can,
Right.
it's a 40-meter corridor or slightly more, depending on.
Okay, so the yellow line represents a 20-meter offset from an underground piece of infrastructure. Okay,
Yes.
so there's already the 20-meter there. For the below ground stuff, does an additional setback apply from the edge of that mapped corridor?
No, not in terms of our recommendations, but First Gas have sought a 60-meter setback from the pipeline.
From the 20-meter setback?
60-meter setback from the pipeline for
So
gas transmission sensitive activity. So an additional 40 meters from that yellow line.
Okay, so the where the recommendation is to include the pipeline corridor extent, and you've got that example there where you've got the Waitara Valley offtake, which is presumably an above ground building structure. The hashed area itself is the edge of the building itself, isn't it? So that does not, by the mapping, incorporate any further setback adjacent to that above ground infrastructure.
No, not with the current approach.
So sorry, Nicola, you're sort of been left sitting in the room by yourself while we talk to the council planners. Is First Gas's intention that, for example, I mean, putting aside the below ground corridor setback, with the above ground infrastructure, what's the additional, presumably reverse sensitivity style setback that First Gas is asking for in terms of the above ground buildings and infrastructure?
Yeah, so, oh, sorry, no, you go.
Oh, no, you go, sorry.
I was just going to say, our intention is to be able to have a seat at the table to talk to these adjacent landowners or developers, if you like, within those setback areas that we're seeking. It's because what we're experiencing, particularly in Auckland South, is those, if I back it up, these are places whereby we may need to vent gas for perhaps emergency reasons or to carry out required maintenance. And so just by enabling us to, within the district plan, have a seat at the table to talk about what may go around our sites, enables us to ensure it's, I guess, the appropriate type of development occurs.
Yep.
So within the rules itself, yeah. Sorry.
What sort of distance are you talking about? 100 meters, 80 meters, 20 meters?
So, yeah, so if we consider the pipeline corridor, the underground pipeline, it's that 20 meters as shown here, with respect to certain rules. And I'm going to be honest in that this is my first hearing under MPDC and my previous colleague was dealing with it, so I don't have the exact rules, but there'll be certain perhaps earthworks or residential properties. Please correct me if I'm wrong, Jamie. And then with regard to the above ground station sites, what we're seeking in this evidence, I guess, is 30 meters around the parameter. So so there's a fence line and it's 30 meters from that parameter there that we're able to discuss what development occurs there. And with regard to the sensitive activity, sensitive activities, the 60 meters, which we've sort of held as a discussion point, is more to do with places where crowds might end up being within the 60 meters. So you're talking sort of more the prisons and marae and larger format type of development.
Mm.
Does that help? I'm sorry, that wasn't very clear.
Well, I guess I'm understanding that. Well, I think I understand. You still want. Do you want a mapped setback, or do you just want a rule that says within X meters of the above ground infrastructure shown on the plan maps?
I believe both, because the maps help to clarify quite visually.
Yeah.
Okay.
All right. No, I've got that. Thanks. Thank you, Stephen.
Yeah, thank you. And thank you both Jamie and Nicola. As I said on Friday, there's a bit of a head scratcher when you're just reading through the background. Nicola, your evidence does help bring into focus the issue for First Gas, and I understand we've got a process moving forward that Jamie and Ashley will be in dialogue with you, First Gas, through you, Nicola, about any further mapping information, and then in Ashley's write a reply on the mapping in concert with Jamie, you'll look at this issue again and give us some advice. That's where we're up to, I think.
Great.
Yes.
Yes.
Sounds good.
Thank you very much.
Thank you.
Thank you, Nicola, and welcome. Sorry, I said at the start I didn't think there was any new people, but you haven't been before us, have you, Nicola, before?
No, I haven't.
No. Okay. Well, welcome to our little hearing family. And yes, thank you for. I know it's perhaps this arose with a bit of urgency, and you certainly put together some helpful evidence for us. We'll see how we get on. Thank you very much.
Thank you. I appreciate the opportunity. Cheers.
Thanks.
Right, we're now moving to Ngāti Rahiri Hapu and Mr. Holswich. Morning, Keith.
Good morning, Mr. Chairman. Good morning, Commissioners. Tēnā koutou katoa. Kia ora whānau. I see that there's some whānau listening in, and my name for everyone is Keith Holswich, and I've been tasked to represent my hapu during these proceedings. I had hoped, Mr. Chairman, to have Mrs. Marsh online this morning after her very long and very arduous but very successful cultural monitoring activities at Epia Road over the last 6 months. That project is finally finished, and hopefully Mrs. Marsh can join us at some later time.
All right, thank you, Keith. Just give her our regards. It's an interesting interesting exercise that's been going on during our hearing. So appreciate the update, because we saw that site obviously on one of our site visits.
Yes. If I get onto my speaker's notes, Mr. Chairman, I had originally written way back earlier on about 9 pages of information that when I reread it was completely out of scope. So I threw that away, and these are just simply speaker's notes that I'd like to speak to my speaker's notes if I can.
Yes, certainly.
And in the introduction, I talk about how way back when we started, we wished our aspirations to be reflected in the proposed district plan. And it was hoped that the GIS and mapping facility would go some way to fulfilling those aspirations, but we feel a bit let down. And it's probably because of my experience as a GIS person that I've been a bit disappointed in the final outcome. It appears to us that the mapping at this stage is a work in progress. It's got huge potential, but at this stage, it just doesn't seem to fulfill our requirements. If I move to the background, it's paragraph 5. When the new mapping program was initiated, there was a focus group put together by practitioners, surveyors and planners to input into what the new mapping system should look like. Unfortunately, that focus group didn't last very long, and we came up with some wonderful ideas, but in the end, it appears that most of the ideas that we wished to be included were overwritten by the requirements of the software developers. That's just my personal opinion. And that's led us to say that perhaps the mapping system for us is flawed, and the way it's set up will hamper what it is that we wish to do. If I go to paragraph 7 and I talk about our original submission, and we supported the fact that council were putting together a mapping system, but there were issues specifically with overlay matters, zooming matters, and our sites of significant identification. And in our further submission, we supported the submission of other hapu and iwi groups. In my executive summary, I've made a big blue. In item A, when I looked at the GIS system some weeks ago, I thought council had made a wonderful enhancement onto the system. And so I said there how wonderful it was that this enhancement had been made. It was annoying that nobody had been told of this enhancement, whereas in fact, the enhancement has not been made. And I'll talk more about this later on, but it's regarding the aerial background, and that if you wish to see the aerial photograph on the proposed district plan in its full glory, all other layers are overwritten, including our sites of significance. And I'm just a bit concerned that if people push the wrong buttons on the GIS system, then our sites simply disappear. But I'll talk about that later on. We note from the Section 42 report that council are committed to improving the mapping system, and we appreciate that very much. We would like to suggest that any improvements are documented and made available to users, and users perhaps can sign up to a newsletter so that if an improvement or an alteration is made, we know straight away what that improvement or alteration is, rather than have to find out about it by trial and error. But that's just something for council. And I think, Mr. Chairman, most of my suggestions are probably directed at council more than yourselves, but I thought I'd just let you know what we're thinking. Overall, in item C, we've summarised that we think that the mapping system based solely on properties is flawed, and that will hamper the full benefits of such a system. And this was discussed last Friday, I think it was, and the existing council GIS system is object-based, which in my humble opinion is far superior to a property-based system. In an object-based system, you click on anything you see on the screen and the attributes are shown. Whether it's a property, whether it's a site, whether it's a point, a line, a sewer line, a water line, that information is shown. On a property-based system, you only get information pertaining to that property and nothing else. Now, an object-based system is the way that the Wellington City Council currently use it, and that's a wonderful system. The property-based system is, I note, is being used by Porirua, and that's got the same limitations, I believe, as what the new Plymouth system has got. Carrying on from that, and this is not under C, and these are my notes on notes, if you like, Mr. Chairman. And we wonder what checks and balances have been made on the data. And our experience to date shows there are some gaps in the information, in that some properties cannot be searched for in the new system. They can be searched for under the old system, but not in the new system. You type in an address, the information address not found. And so all we're suggesting here is that perhaps there can be a notice board set up somewhere such that if we come across matters such as this, we can simply post to council and say, hey, look, we've noticed this little problem. Can you fix it up? And I don't see that anywhere in the system at the moment. And just for an example, if council are listening, perhaps if they type in 110 Stockman Road, they will see what we're talking about. In the old system, 110 Stockman Road sends you to the property. In the new system, 110 Stockman Road doesn't exist. So the question there was, how do we advise council about small errors such as this as we go along? In paragraph D of that section, I talk about council's decision to only partially implement the requirements of the national planning standards, even though section 42 report says they are fully implemented. And I'm talking about here specifically the NPS requirements to allow layers to be switched on and off, and by implication be visible at any layer. And there's a huge section in the section 42A report that talks about this. And no matter what default scales are set, and I can agree that some default scale should be set, there still should be the ability to switch on and off layers as required. And that does not happen, but is most certainly required under Appendix 16 of the National Planning Standards. So that's something I think the council need to look at. In section E, I talk about council's decision not to implement useful advice offered for future plan practitioners. And I say that decision is flawed and will hamper the system. And I was concerned the other day to hear on many occasions, that was last Friday, Mr. Chairman, that the terms lay user and user experience mentioned. Now, without the benefit of statistical information that council will have, I would be surprised if there were more than a few lay people who will use this e-plan once operational. And so therefore, as such, I believe the user experience of the mapping system should be geared towards active practitioners, being surveyors, planners, lawyers, and iwi, and not for any lay user, as has been suggested. It's almost as if the system is being, I don't like to use the word, but being dumbed down. And by dumbing down the system, flaws are appearing in it. Under section F, I discuss council's decision not to include all available information to allow practitioners to prepare a detailed analysis on all planning matters. And I say that is flawed and will hamper the full benefits of such a system. And this was raised by surveyor Vaughan Redshaw regarding existing service information, utilities information. The existing council GIS system includes all necessary information required to allow any practitioner to make an informed decision, and indeed allows us as iwi to make an informed decision. Now, given that the council wishes the mapping system to be user-friendly, it's rather confusing to read in the section 42A report that any information that is not included in the system can be downloaded from council web portal and be included into anyone's personal GIS system. Now that's hardly user-friendly to any lay person. And it's not friendly to us as iwi, and it's not friendly to practitioners. However, if it's council's decision to keep both GIS systems going, the original system that's being used now, which is a wonderful system, and the new e-plan system, then it's awkward, but it's good. Because the original system has got all the information required for us to make an informed decision. If the original GIS system is to be discontinued, then we're going to have a problem. And I suspect, Mr. Chairman, I've got a wee note here in red on my speaker's notes. A lot of this may be outside of scope, but I'm just pointing out how difficult it is going to be for us as iwi to make final decisions if we're looking in more than one place. And I would have thought that the e-plan and the mapping system would have been the be-all of end-all, where everything we need is in the one place. And moving forward, Mr. Chairman, under section G of my notes, I say that a focus group of all practitioners using this mapping system should be initiated sooner rather than later, so that professional user input can be applied to the system. And I talk about, again, surveyors, lawyers, planners, iwi. Let's sit around the table and tell council what it is that we require and what we need. As I said before, it appears at the moment the system is being driven by software developers that perhaps don't have the practical user experience that we have. Moving on, Mr. Chairman, I've got on there a list of matters to be addressed. And in section 9, I talk about the section 42 quite clearly sets out the council recognise limitations of their system. However, it's what council proposes to do to address these limitations, or indeed ignore them, that is of concern to us. And I've previously mentioned that if data is missing, you go onto the web portal, you download it, you put it into your GIS system. That's not how a GIS system should work, Mr. Chairman. I'm reporting here under section 10 as a GIS user for the last 30 years and with formal undergraduate training at Massey. And I can't understand the path that council are taking here. I will fully accept, Mr. Chairman, that I'm very long in the tooth, that my training was 30 years ago. But when I looked at all of my research books and all of my documentation from that formal training, I don't believe anything has changed. The basic fundamentals of a GIS system are still there. I don't think council have got this right. It's happening all around the country, the same software developers. Sorry, you can't convince me it's right. In paragraph 12, I set out what the NPS quite clearly requires with respect to viewing differing layers. And I've mentioned this before. Council's solution appears to be rather ad hoc and most certainly does not comply with the NPS requirements. And I mention this because council are talking about scales, particular scales, automatically turning layers on and off. That's fine. It doesn't comply with the NPS requirements, but that's easily fixed. You simply make all or any layer viewable by selection at any scale. Yes, the map may be overbearing, but it will comply with NPS standards. And that's a simple fix to a problem. Council uses our Mountains National Park property as a guidance to how various layers should look. That's disingenuous. That's a ginormous big property. It's the largest property in our district. And for council to use that as an example of why things can't happen is not right. Paragraph 13, and this is of huge concern to me, and it's regarding our sites in areas of significance. Council is suggesting that because there's only very few sites that are not within specific properties, therefore accessing these sites appears not to be a concern to council, and that we should simply go back and find out the number of the site, click 6 or 7 times into the e-plan to find out what that site is. That's being disingenuous as well. It's a complete disservice to us as hapu concerned with protection of our sites and to the sites themselves. But there's a very easy fix for this also, Mr. Chairman. It's my understanding, looking at my GIS system, that the roading system of New Zealand, every section of a road or a portion of a road is given a LINZ ID number, in the same way that every land parcel in New Zealand has a LINZ ID number. It seems to me that council could simply attach a site of significance to a particular road portion number, a parcel number, and therefore make that site searchable simply by clicking on the road parcel that contains that site. By council's admission, there's only a few such sites, so it would be a very minor matter to address and sort out. It took me 5 minutes to do 2 of our sites in our rohi that are on the road reserve, to actually put those sites onto a parcel layer on the roads. 5 minutes. So it's not a huge thing. And the example that was given in the section 42A report, I think it was that one, yes, was the cenotaph at the Queen and Street and St. Albans Street intersection. I think that's site number 7. That happens to be contained within the road polygon ID 4679906. Why can't that road polygon ID be used like a property ID so the site can be searchable? So there's one very late matter I'd like to raise, and it wasn't included in my original speaking notes or in my original submission, but it came up on Friday, and that's the determination of a 5-meter radius around a single site of significant feature in the mapping. We could never accept that in our rohe, as such a point or a feature is seldom found in isolation and invariably as part of a wider landscape. And a classic example of that is the site at the end of Epiha Road. There was a stone sinker, fishing sinker, was found 50 meters away from the current site, and we put a 50-meter buffer around it. Just outside that 50-meter buffer was one of the largest, most significant village sites ever found in North Taranaki. By putting a 5-meter radius around such a point or a site, I think does a disservice. And it was not in our original submission, but we would not accept that in our rohe, a 5-meter radius. We would accept a 50-meter one. I'll stop there, Mr. Chairman, and get on to my conclusions and recommendations. I think what I've talked about today has been in scope. The 9 pages I had prepared, I think, were out of scope and were more instructions for council. We asked council to have the vision to address the matters we've raised and to involve all the users and practitioners in any future development upgrades of the mapping system. And I've got there that we humbly ask that the hearing panel may also take our matters into consideration. But in reality, Mr. Chairman, I'm not sure how you can help us out here. I think these are operational matters to do with council, and we're simply expressing our views. And that's it, Mr. Chairman. Thank you very much for the time to listen to our presentation. And of course, we're happy to take any questions or discuss any matter we've raised as may be appropriate. And I recall off my notes a bit of jousting I had with Commissioner Littlewood right at the start of these hearings about this GIS system. I look forward to some searching questions. And that's all I have. And to you, whānau, tēnā koutou katoa. Thank you very much, Mr. Chairman.
Thank you very much, Keith. We'll start with Antoine for questions.
Thank you, Mr. Chair. Hi, Mr. Holsbush. Thank you for your submissions. It was put to us on Friday. There was a number of, we'll say, issues or limitations or shortcomings in regards to the amount of information that a user might encounter when they enter the GIS. And one of those options was being able, once you go in, all the layers are turned off, so you have a clean map effectively on your screen, and then you can turn on the layers. Is that type of approach one that you think is consistent with the MPS? Because you were just having a conversation with us about you think it should be targeted towards users, and one of the issues that I'd raised was, you know, a layperson might not know which layers to turn on, but an experienced person or a professional probably would. And I just wondered whether you had any comments in that regard.
I touched on that in that I believe council are probably on the right track about having zoomed layers. When you go into particular zooming areas, layers automatically turn on and off. But for the experienced user, I think you should still be able to switch layers on and off as required. So it's half of one, half a dozen one, 6 of the other. Council are on the right line, but they must allow layers to be switched on and off.
Thank you. You raised the issue of the 2 systems, and I thought that was an interesting point. I wonder if you could just perhaps provide us a little bit more information about that. I'm particularly interested in the types of information that you think are really important that are in the council's GIS that may not be in the E-plan.
Oh, yeah, the existing system is like an old pair of socks, very comfortable to use. It's got all of the utilities. So if I put on my surveyor's hat, we are bound by the E-plan to consider all sorts of matters, which includes servicing any subdivision. The existing GIS system allows us to click on those lines to find out where the sewer lines are, where the water lines are, all of those necessary matters outside of the particular property. The new E-plan does not include any of those underground services. And that was raised by the surveyor Vaughan Redshaw. So if the two systems are to go hand in hand, and I see the E-plan, the new E-plan, as being a wonderful planning tool, but it's not, as a surveyor or an iwi person, it's not a useful tool to see what's going on. If we're going to build our new marae at the end of Epower Road, we need to know where the water goes. Under the new plan, we don't know. If the old plan is discontinued, the only way to get the water is to download the water information from council portal somewhere and put it into our GIS system. And that just seems to be inefficient, that's all. Maybe it's something that the new E-plan can expand upon at a later date, although the Section 42A report says that can't be done because it's a property-based system and any services that are in the road can't be accessed. So I think there's a flaw there.
Yeah, it's an interesting point you raised. I'm glad you just interpolated a little bit, because I was thinking about if you're in the field and you're wanting to get information about a property or a site of significance to Māori or a utility. The plan is one source of information, but there'll be others. And I was wondering, yeah, it's interesting when you're on site, how do you get that information? And it might be on a handheld device as commonly these days.
Absolutely.
But you might have the benefit of having a laptop in your vehicle. The way in which you're able to get that information in a timely manner without necessarily having to go back to the office and download the software, download the shape files, et cetera, et cetera, et cetera.
Correct.
And yeah, so it's interesting. It seems like that connectivity, that integration might be something that the plan may head towards, but it certainly doesn't seem like it's there yet. There was
a work in progress, and perhaps if the practitioners formed a focus group and said to council, this is what we need, maybe it can be done.
My last question was just around the 5 meters radius. It's an interesting one because I think there seems to be 2 issues here. One is that there's the sites that have been identified in the plan,
yes,
and the nature of some of those sites is quite finite. Like they might, I think we got a list of those in a schedule, and things like Fire Scoop, Umu, and you've mentioned an object that, or a find site that might be very discrete. That's one thing, and identifying that clearly with some spatial extent helps you really clearly identify this is the area that is affected by this particular item or find. And then we're also talking about another issues around the cultural landscape and the context.
Yes.
And this is something raised in very early hearings last year around the council intending to start doing work in that area of cultural landscape. So you can see, I suppose, a continuum. This is, from my perspective, see a continuum where there's been a focus in the past perhaps on archaeological sites, archaeological values, and very much on the site and the features, to a sites and areas of significance to Māori that takes on board archaeological values, but a number of other values. And then we've been hearing from iwi submitters in regards to natural heritage, natural values that also can have a bearing on cultural values related to sites and areas. And then we're starting to have those conversations about cultural landscape. How do these sites and areas relate to each other? And then what are the planning implications for it? So I'm sort of that's in my mind, that's a continuum of where planning is heading. And I just wondered whether you had any comments in regards to where the E-plan is right now.
Yes, I think we raised that at an earlier hearing, and we were talking about non-regulatory layers, information layers, and that wider cultural landscape can be included in that non-regulatory layer. So that, yes, you've got a dot on the plan with a 5 metre or a 50 metre radius around it. But if it's close to a river and up and down that river is known sites, there's every likelihood that something around that particular spot is part of the cultural landscape. So yeah, that was my only solution, was to have a non-regulatory layer. How that fits in with the new E-plan, I'm not quite sure. It's easily done on our system. It should easily be done on the council system.
Yeah, and you'll be aware more than perhaps others, you know, the system that Ngāi Tahu runs with, they've got a number of, I don't know if they call them cultural landscapes, but broad areas where there's particular significance for a number of reasons. There's the Ngāti Kahungunu, Hawke's Bay area have got a number of GIS systems which are publicly available, which identifies like iwi management plan areas, customary areas, all sorts of information. I just wondered, are those the types of things that you're thinking about?
Yes, yes, and I think we showed an example of that, of how we dealt with the oil companies regarding seismic works,
Yes.
where we put buffers around sites, areas, rivers, anything like that. So yeah, that's how we've dealt with it, and there's no reason why the council can't do that as well. We would like everyone to come to us when they're in our rohe so that we can tell them what's going on, but they need to get some sort of information from council initially.
And you, just my last question, sorry. You said that you've noticed a number of areas, and you gave an example where an address doesn't seem to exist in the system, or doesn't recognise it, and you've also suggested perhaps everything in GIS has this is my words, a site identification, you know, a specific identifier that's epic on anything, it means something. And I just wondered whether you've set out a process for us, because I always take the view that no system's perfect.
Yep.
And good is good, but you want it to be great.
Yes.
And I just wondered whether you had any further comments around, you know, there are going to be errors, there are going to be inaccuracies, there may need to be tweaks over time, and understanding this is a E-plan, and there'll be a difference between those sort of minor amendments or corrections, and they don't have any impact necessarily on landowners, but where significant errors occur that require changes, whether you just had any views in regards how those might be dealt with from an iwi perspective.
For the minor ones, it would be easy just having something on the screen that says report a fault or report an error, and that then becomes a portal where we can just keep feeding in, and I'm sure there's probably dozens. I presented my GIS system to the hapu on the weekend, and the first button I pushed didn't work. There is always going to be errors in the system. We just need a reporting. Who do we speak to? I don't know at this stage. The minor ones can be done in that way. The major ones, of course, would have to be dealt with the plan change later on. But just a reporting facility, that's all I would suggest would be a very good idea.
Thank you, Mr. Holswich. That was all my questions, Mr. Chair.
Thank you for your question.
Thank you, Antoine. And Kit?
Yeah, it's a difficult job, Keith, trying to make a new pair of socks.
Indeed.
I like to think that in time, this pair will be as comfortable as the old pair. Won't be as scratchy, not so tight around the ankles.
My rocking chair and whiskey glass will be used more often then. I won't be worrying about that.
Hey, no, all flippancy aside, I think you've got some really good ideas there. And I particularly like the ideas around there being a way for users to have real-time information about updates, even if they're minor, or to be able to prepare, to report a fault, or even, and I imagine it may evolve in time, even a little user chatbot down the bottom corner, where those who are not familiar with how the whole thing works have access to virtually one of I'm talking about these new chatbots that have sort of
Yes.
evolved, a little bit of AI going on behind the scene, but they work by actually identifying 80% of the similar questions that always get answered and always have an answer for them. So, I mean, there's lots of ways that these sorts of interactive tools are being explained on the go to people. So I think there's lots of opportunities there. To some
Yes,
extent.
absolutely. I'd like to get involved with that as well.
Yeah, because I initially sort of screwed up my face at your point. I know we should make this plan sophisticated, assuming that everyone who's going to be using it is going to be smart and knows what they're doing. But I don't know whether the general convention around access to justice and access to public information sort of lets us do that comfortably, because if the average person is not able to access this information, then I think we've done something wrong. But I agree, tailoring it to the average user can have problems in that you lose a degree of sophistication. So I think you're on. You're onto something when we think we need to have something that fairly balances it, but enables users to get the things that they don't understand explained to them in real time, but also enables those who are sophisticated users to go straight to the bit that they want without having to go through all of the kerfuffle.
Absolutely.
So I think, but I think a lot of those are around implementation and usability more so than the information that's been constructed into this model.
Yes, operational matters. Yes.
Yeah. So no, I think you've got some good ideas there, and that's sorts of things I'm sure we'll discuss in a lot more detail.
Thank you.
Thanks, Keith.
Thank you, Kit. Just a couple of questions from me, Keith. The first one was about the object-based approach that Wellington City are using. Their proposed plan is due to be notified in July, as I understand it. So you've been looking at Wellington City plan yourself, the draft version, or is that
I didn't go into the e-plan. I remember doing a lot of work on the monastery a few years ago, so I thought I'd just pop in this morning to see what they were there, and of course they're still using the old version.
Oh, right.
And it's still got all the information I looked at all those years ago for the monastery work.
Okay.
I could never have got that information on the new e-plan.
Okay. And I think you were listening on Friday. I was asking Ashley about the various councils and where they're up to. And I was, so, I've listened with interest to your evidence, the what might be suggestions that you're posing as a practitioner and as an iwi person. It's been very interesting for me, and I think in terms of our role as commissioners and decision makers, we'll certainly take those on board, and certainly hear back from Ashley and the council team on whether any of these matters might be able to be implemented. Council certainly being very open to good ideas from what we can see that are within the realms of being able to be implemented within the constraints. The one area that I do want, obviously, Ashley, for you to come back and comment on is where Keith suggests that the mapping isn't in tune with the MPS, because that's something we will have to really turn our mind to. And so no particular questions. Oh, I did have a question about the 5 metre buffer, Keith. Seems to be a philosophical issue where in the SASM hearing, we heard a lot about, just a point on a map was meaningless without the wider context. And it was a bit of I think Joe Ritchie, who was a reporting officer, was trying to sort of provide a bit more focus around just a fine site than just the point on the map, which may not be very accurate in itself, just to bring that perhaps in a mapping sense to be a bit more highlighted. Whereas I think philosophically you're saying, well, that might imply that that's the only area of interest, and therefore the mapping or the highlighting convenience of a wider site to make it stand out a bit more might have an unintentional consequence that in terms of the way the plan works, that the wider area may not have, be signalled as an area of wider interest. So it's a judgment call, isn't it? I think
it is, and that's we just judged 50 meters when we did ours, because there is a 50-meter radius in the old plan around any site. So we just put a 50-meter circle there. And I note that's now down to 5. I don't think we would accept that. Others might. At least it's on the plan. That's the main thing.
Yes, certainly Murray has got some evidence for us, and I think Sarah as well. So we'll hear some more about this, I'm sure. So as always, Keith, really great talking through these practical issues that you raise as a surveyor and as a iwi person, and just as obviously a plan user with real interest in these mapping tools, which are absolutely vital to the success of the plan. So thank you very much.
Thank you. Retired surveyor, Mr. Chairman.
Yes, you've made that point a few times. The skill set still stays, doesn't it? Even if you've got a retired brackets beside your name.
Yeah. Thank you, commissioners, for your attention to the points I've raised. Thank you very much.
All right. So welcome, Liana. I see you're there. We'll take a break until 11 o'clock. But Liana, just to let you know, we've just had some evidence come through our email. We'll have a quick read off before you come on, but welcome to the hearing, and we'll hear from you at 11 o'clock. Thank you. Thank you, Christine. So Sarah, you're gonna give a bit of an introduction?
Yeah, I'll just start us off if that's okay.
Thank you.
O tuatahi, tēnei te mihi ki o mātou kaikohimana, tēnā koutou katoa, tēnā koe Antoine, nau I tuku karakia I te atanei, tēnā koe, o tira, e te whānau, tēnā koutou katoa. So just wanted to start off with a big mihi to everyone. I know we're working through these very interesting times as well. So Commissioner Dash, hope you're, well, piki te ora, piki te wairua, hope you're feeling much better anyway. So this morning, you will have received evidence, Liana's evidence, that she's going to speak to in relation to the treaty settlement whenua. Then I've got some brief notes. I didn't attend on Friday, so Maddie is going to wrap that up for us this morning. But anyway, I'll if there's no questions, I'll pass it over to Liana if that's okay.
Thank you, Sarah. And no questions. We'll just hear from you, Liana.
E oku rangatira tēnā koutou katoa, me aku whanaunga, kei runga I te hui ārangi e me I ana ki a koutou katoa katika. Me tuku mihi ki o tātou nei mate, huri no ki a tātou ngā kanohi ora e haere tonu I ngā mai. Ko Liana Pautu tōku ingoa, no tia tiawa me taranaki iwi ahau, e noho anau ki ngā motu. So good morning everybody, Liana Pautu is my name. I'm of Te Atiawa and Taranaki descent, and I live here in Ngā Motu, New Plymouth. I'm the current Pou Whakarai chairperson for Te Kotahi Tango Te Atiawa, which is our post-settlement governance entity. I know that you've received a statement from me. It's a brief statement, so I don't propose to read through it. A lot of it is contained in my previous statement to hearing 13, but I will just pick up on the key points. So as I said, I'm the chairperson for our PSGE, and I'm also a director on our commercial subsidiary, Te Atiawa Holdings Limited Partnership. So my statement to District Plan Hearing 13 includes my background and governance roles. And also, obviously, I'm providing this statement in support of our Te Kotahi Tango Te Atiawa submissions. Now, I think a lot of what I've put under the heading of Summary of Evidence to Hearing 13, I know Commissioner Littlejohn, you wouldn't have heard that. But essentially, it's a bit of background about our Treaty of Waitangi claim settlement. We signed a deed of settlement with the Crown in 2014. Our settlement legislation came into effect in 2016. And within that evidence, it sets out the rights, property rights essentially, among other things, of which we have rights to exercise deferred selection over properties, which is a deferral to purchase properties that are currently in the land bank or were in the land bank. And we also have an opportunity for right of first refusal over some properties. So they're in two categories for us. The first category of right of first refusal is an exclusive RFR, which are set out in our deed of settlement. They're specified properties. And then we have a second category of right of first refusal, which is over in an area that's a shared area of interest with our neighbouring iwi, Taranaki iwi. And so that's not a specified property list, that's a list, essentially that's an area. So if a Crown property comes up in that area, we have a process by which we exercise an RFR, but they're not specified as such. In my previous evidence, I talked about the fact that under our treaty settlement, essentially our history is one of confiscation, murume te raupatu, and at the point of settling our treaty claims, we were essentially landless as an iwi, so we didn't collectively own lands as an iwi, and that was a result of confiscation and other Crown actions against us. And so one of the things that we're really working towards now that we're in this post-settlement space is really reclaiming some of the whenua in Aotearoa, re-establishing ourselves. I know that I talked about one of our key aspirations as a part of settlement, being able to re-establish our identity and presence within Aotearoa, but also to reimagine and recreate and maximise opportunities for our people through rights in our deed of settlement, as well as other sites that we might acquire, and really seeking enablement and empowerment to do that within the New Plymouth district. So I know that's a brief, quick overview, but two of the commissioners have heard that before. I guess the key focus for this kōrero is based on the treaty settlement land definition, which sits in the strategic directive objective TW11. And I think it's also referred to in the Papa Kāinga definition. And essentially, I guess there's 2 points that I want to raise and talk about. Is one, I think that the definition is quite narrow of treaty settlement land. And also I think that it should be renamed as such. So one of the things that I acknowledge that the definition includes DSP and RFR properties, but what it doesn't recognise is the fact that I talked about we have to acquire property, and not always, that property won't always be Crown property that sits in the DSP or RFR category. And especially if I'm looking at land that might be adjacent to marae or adjacent to sites of significance often they are general land. And so if we are to acquire them, we're acquiring them as general land, and therefore they don't fit within the category of Māori land, which is also in that strategic directive objective. And they also, because of the narrow view of treaty settlement land or definition, they don't fit within that either. And so our request, I guess we're seeking that that's changed to make that definition more enabling for our, not just Te Atiawa, because I think it applies to all of our PSGEs and our hapu, to, you know, if we want to meet those aspirations we have for social, cultural, economic development, unnecessarily limiting the definition of treaty settlement land actually goes against that. And so we're seeking a broadening of it. And if I look at, even in the current definition, there are 2 exclusions which talk about the unspecified properties in the area RFR I talked about. I talked about those 2 categories of RFR. And the second category over the area is not included. So if we were to acquire a RFR property in that shared area, that wouldn't be covered by this definition. And it would work the same. It wouldn't be covered for Taranaki iwi either. And then there's another exclusion in there that talks about lease, if we were to lease the land for 35 years or longer. I mean, I don't believe it's council's prerogative to be determining how we might meet our economic aspirations as an iwi. And one of those might be by long-term leasing, but by providing the exclusion in this definition, we're again limiting what we as an iwi might be able to do in terms of, you know, of achieving our aspirations. I guess, in my view, treaty settlement land includes, well, as it's currently titled, treaty settlement land, includes all land that's acquired by a PSGE, or should include all land acquired by a PSGE or associated hapu. And that's regardless of the mechanism, because we talked about that context of confiscation, and we're trying to, you know, we're having to repurchase land in Aotearoa, but this definition prevents us from, or prevents it from being included in terms of the strategic objective, because in the main, land will be general land that we acquire, and so it won't be covered by the strategic direction. And so what I am suggesting or proposing is that we should change the use of the term treaty settlement land, because that's a very colonial one in my view. I mean, and it you know, it continues to keep us in the past by using that and referring to us as settled iwi. At the end of the day, we're tangata whenua. We're here, we have always been here. And so I think that the category more aptly should be called iwi and or hapu owned land, because there are instances also where hapu, they may acquire land to develop in their own right outside of a PSGE, but they shouldn't be excluded, or that, you know, the definition of treaty settlement land shouldn't exclude them from being covered within that strategic objective. So there's a few, I guess I have a few issues with the definition, in that it's very limiting and it doesn't take into account all of the land categories and opportunities and examples that iwi and or hapu might acquire land, and therefore would be covered by this objective. I guess another example is, for many of our iwi, we provide distribution to our hapu. And so we provide distribution to our hapu. If they were to use that distribution money to purchase land to do their own development, that would not be covered by this current definition. And in my view, that's wrong, because it's all about empowering tangata whenua, reclaiming land, achieving aspirations, but this definition really locks us in to a particular framework, and I don't believe it's empowering enough or enabling enough. So I think I probably covered off the key points, the 2 key points, and obviously happy to answer any questions that you may have.
Thank you very much, Liana. Antoine?
Yeah, thank you. He mihi kawana kia koe, Liana. I runga tō tūranga o pauwhakarai o Tiatiawa, o tiranga karangarangatanga kei wainganui i a koe. Good to see you again, and thank you for the evidence. I thought it was, when I had a read of it this morning, it was very thought-provoking, because we have all these constructs that are, like treaty settlements, which go some way to redressing the wrongs of the past. But we, as decision makers, we need to be cognizant that we don't continue or perpetuate injustices or perpetuate systems or frameworks which carry on the injustice in whichever way it might find its form. So it was a very good reminder of that role that we play as decision makers. Albeit we're just talking within the context of a district plan, but it's something that we need to be thinking about all the time. And so I really appreciate the evidence, and also some thoughts about how the matter might be resolved from your perspective. I thought it was interesting because where we started was we were talking about Papakainga and in the hearing for Papakainga, the Māori purpose zones enabling tangata whenua, iwi and hapu to resettle the ancestral lands, and trying to find an appropriate way where you could do that in a informed, well-connected and integrated way, understanding that we've got to consider the effects of different types of developments on those lands, and being sensitive to all of the different things that we need to consider. So to say this is easy would be wrong. This is a complex area. It is challenging. However, when bright people all come together, you usually can find an answer or a solution there. So that was a long-winded way of just saying that this isn't easy, and there isn't necessarily there could be a quick fix, but it might not be as elusive as that. So we started with Papakainga, and it was looking to extend the categories of land to be inclusive and enabling of the Papakainga zone. And so we ended up with, certainly in that hearing, was Māori land under the Te Ture Whenua Māori Land Act, treaty settlement land, which would be identified either in the legislation and or the deeds of settlement. And I don't know if we really got right down into the detail of exactly what were the classes of land that would be included in the deeds and the schedules. But I was certainly of the view that those would be inclusive. But where we see the definitions as they're set out there, it's quite clear about what is included and what's not included. So I think that the point was well made about, well, how does that then fit in terms of going back to where we started from, in terms of the Papakainga and enabling settlement of the ancestral lands. And you've provided some useful suggestions, iwi or hapu land, and I was flicking between the definition of treaty settlement land and the Papakainga one, and wanted to actually including a iwi and hapu land. Perhaps that is actually a quick fix. Or am I thinking way too hard about this? And that would be an inclusive way. And then perhaps don't need to be so pedantic with the treaty settlement land definition, because it's covered, it's been inclusive in the Papakainga one, if you get my understanding. So I was just sort of I'm talking through a train of thought, and I just wondered if you had any further comments in regards to that.
No, I agree with what you've said. I guess we've got an exact situation where there's the potential for land adjacent to our marae, which is general land,
yes,
acquired, and if it was used for Papakainga or other hapu developments, it could be a I don't know, a cultural centre, for example, that would not fit the definition as it currently is. And that, in my view, is wrong, because that's the whole point, right? We're trying to enable Papakainga development, especially if it's adjacent to a marae. But if the definition don't allow it, that defeats the purpose of the entire objective, in my view. Yeah.
Yeah, and it seemed to me like a number of the iwi and a number of hapu are very active in the space of working with developers, landowners who might be subdividing for whatever reason. And you often get opportunities where land may be able to come back to iwi or hapu ownership, but the mode or the vehicle in which that occurs might not be a treaty settlement per se, but it's actually some arrangement where actually the iwi and or hapu take control of that land and for all intents and purposes own it, but it doesn't fit one of these classes of settlement in it, and it might be exactly as you said, adjacent to the marae or a site of significance where you've got an arrangement for some housing or all those types of arrangements that could be that are unforeseen at the present time, but could be quite plausible in the future, would be precluded. So I think it was a point well made. So I'm quite keen to hear back from our report writer on the definitions. It's a little bit connected, or it is connected to the Papakainga section as well, special Māori purpose zones as well. So those two are connected, and as it turns out, I'm going to be the author for the Māori purpose zone, so I'm quite interested in where we go with this one. I'm just going to perhaps pause there, Stephen, and just see if Kit's got any questions.
Thanks, Anton. Tēnā koe, Liana. I don't think we've met. I regret that it's over this medium and not in person. But by the look of it, I'm going to be spending most of June down in Iorohi, so I hope to find an opportunity to catch up then. I agree with you that if we're going to look at expanding this notion of treaty settlement land to be more inclusive of land that's under the control of Māori, then I think we do need to relabel it. I think I think the words in that situation have just outgrown what we're potentially going to see this concept do. So I think that's the first point. I don't have a problem with that. We're in very interesting times constitutionally, and this discussion is very much at the forefront of that. A lot of other councils have grappled with this, and for better or for worse, and I look at how Tamaki's done it in the unitary plan, is a very exclusive definition of treaty settlement land. It is very much the conventional approach of RFR or deferred. So it's only properties that come back acknowledged by the Crown as part of a treaty settlement, and sort of quite narrow to that extent. And I don't know the rationale for that. I don't know whether similar arguments and requests for it to be a more inclusive term and used broader were put to the unitary plan panel. So I've got to look at this within the context then of the Resource Management Act and ask the question, is there something in the Resource Management Act that ought to limit recognition and provision for ancestral relationships simply to land that the Crown gives back through mechanisms following a treaty settlement? And my sort of initial high-level view is that it doesn't, that the Act is much broader to that extent. Section 6, I forget the subparagraphs now, is not specific to how the land, if it's ancestral land, came to be in the ownership of Māori. Simply that where there is that relationship, that it be recognised and provided for. And I have to say, this is a really elegant way to do it. It respects that relationship. And I think the one thing that makes me more I guess what's the word, comfortable with it. And it's a horrible, comfortable is a horrible word to use in the context of the rest of the sentence. The reason I feel more comfortable with it is because of the specific historical circumstances that affected the Taranaki iwi. Yeah, so that's me just circulating these thoughts around and sort of reflecting them back to you. I mean, I'll be interested to chat with the other commissioners about it, because I wasn't involved in either the SASM or the Māori Purpose Zone. But at a broader level, I think you're onto something, and I think it is quite thought-provoking, but also far-reaching in a constitutional sense. And as far as I can read the Resource Management Act, perfectly within the compass of recognising and providing. So yeah, I mean, I don't want to say I've already made up my mind, but but there you go. I think there's lots of really helpful stuff there for us to think through for the future. Yeah.
Tēnā koe. I think the only thing I would add off the back of that is, you know, if you're looking at comparatives like the Auckland Unitary Plan and here, I guess the difference is the number of properties available for treaty settlement in Tamaki Makaurau is significantly more than what are available in the New Plymouth district. So for example, you know, we have 51 deferred selection properties. I can't just remember the number off my head for RFRs, but ultimately we might not take up any of those. And then you don't have any iwi owned properties included within, you know, the ambit of that strategic direction. And I guess that's the key difference really, is that there are far more opportunities in Tamaki Makaurau to exercise rights over land in your rohe than there are here in Āmotu and Taranaki. Me iana.
Ka pai. Yeah, and lots more room for arguments amongst iwi in Tamaki, as we well know.
No comment.
No comment. Yes. Yeah. All right, ka pai. Very good. Thanks. I have no further questions in that space. Thanks.
Liana, yes, very interesting times and a very interesting topic. And with your experience, you've been in the job since 2014 or in this role, right through the transition and into another world where we are looking at shaping a district plan that reflects sort of perhaps in your words, in your hearing 13 evidence, just reimagining, rethinking what might be. So you've probably already gleaned that the panel was very open to looking at ideas and ways and words that might better represent today's reality, which we all recognise. I do have one question just about that broad term iwi or hapu owned land. I'm aware from some other evidence from PKW, for example, that there's some lands that are in the PKW portfolio that have sort of come back through treaty claims or as leases reorganise themselves, but there's also some other farms that are being looked at for purchase on the open market. So for me, the question for you is this distinction between, let's call it section 6E land, which is the cultural relationship with key areas past Kāinga, Pa, Wahitapu areas, Urupa, where changing the extent of a definition might change the way activities can occur on those lands, and distinguish between those sorts of areas and, let's call it, commercial land. So this is land that doesn't have that direct association, although you have kaitiaki over all of the land, but doesn't have that overlay of the Section 6E. This is an area that's, you know, a 6E area, and whether it's right that new land that is a purchase from a commercial perspective to underpin the economic growth and development of iwi and hapu should also get any benefits that accrue from being named under that definition, the way the plan policies and rules work. So just some thoughts about that distinction, whether you see that's real or whether you could give us some thoughts on that.
Ka pai, I should disclose that I'm a recently elected committee of management member for Paraninihi ki Waitotara. So while I'm not giving evidence as a committee member, certainly I'm very well aware of PKW. I guess for me it comes back to some of the context. So at a principled kind of level, I don't have an issue with the likes of PKW or other Māori land trusts, for example, in Aotearoa, you know, the definition being extended to include them. And I guess the difficulty is how that's included, because technically they're not iwi and hapu, and the shareholders of PKW are not every single descendant of the iwi, the 8 iwi of Taranaki. And so it's very much run as an incorporation, you know, you've got that shareholder relationship, I guess. But the context is that incorporation was established as a result of land confiscations and Crown actions. So it's absolutely connected. And that's the difficulty. And I, you know, although PKW have commercial aspirations and they have a commercial strategy, that's still on behalf of tangata whenua. It might not be on behalf of everybody, but it's still on behalf of tangata whenua. And I guess the key difference for me is talking about collectives. So iwi and hapu are about collective ownership of whenua. And I see PKW in the same category. It's a collective ownership of whenua. And that whole collective ownership, you know, the principle of allowing collectives of Māori to own land and benefit from that collective ownership of that land, I'm comfortable with at a principled level. But I think there are some distinctions to be made between iwi hapu and Māori incorporations and trust. And I think we just have to, you know, be careful. Because some of the PKW land will already be included because it's Māori land. It's under Te Ture Whenua Māori definition. And so if you're including some of their land, it would flow that you would include potentially others where it's, you know, it's general land owned by them. But I wouldn't give PKW the same status as tangata whenua, simply because not all descendants of the iwi of Taranaki are shareholders of PKW. So that would be the key distinction.
Thank you for that. All right, well, I think those are the questions we have for you. Appreciate your attendance again and the ability just to have your expertise, which is very important to us, and having you available for questions is much appreciated. Thank you.
Ngā mihi, kia ora.
Sarah, back with you. I think you mentioned that Maria might go next. Is that the plan?
Oh, I'm easy.
Easy. Whatever's you've arranged between yourself. We're easy as well, as you know. We're accommodating as we can.
I mean, Maria did listen in on Friday, so
Okay.
she's
So she'll go at the end. Okay.
yeah. I think it'd be great if she can wrap it all up.
Yeah, no, that's fine. Thank you.
Yeah.
I think, Mr. Chair, from the last hearing we had, where the order was changed, where Maria was taking a step to balance the bulk of the questions, was where we'd last left off, and I think that was going to be the trend to the end of the hearings, as I understood.
Maybe my older cousin wants to go first. Anyway, we'll get started. Tēnā koutou anō. You know, when we prepare for these hearings, and actually mihi tū Liana, tēnā koe te tuakana. I totally fangirl Liana. If I ever get to be as cool as her, it will be amazing. So at the moment in my te reo class, my te reo Māori class, we're learning to whakapoto sentences, to say things in a much more concise way. And my English probably needs a little bit of work on that too. I write my summary of notes and then it just gets longer and longer. So anyway, I will try and keep as short as I can. But yeah, thank you again. Thank you for the opportunity to speak today, and also mihi to Jamie and your colleague from BOFA, I can't remember her name, and to Ashley as well for the reports. They were really interesting to read when we read them a wee while ago. So I just wanted to start with my notes for the definitions section 42A report. So just reflecting on the kōrero this morning with Keith as well, and all of his experience with the GIS system. So in my evidence, I've just explored the range sets for the planning maps. And I think, you know, as Keith mentioned this morning, I think those scales are really important, and I just highlighted in my evidence as well of I'm aware of two recent instances where because of the scale of the maps that those SASM and archaeological sites, the rules in relation to those overlays were missed, and so retrospective consent has had to be applied for. I guess then that kind of links into the find site extent. So actually those two instances that I'm aware of weren't related to find sites. They were related to sites that one had an extent and one didn't have an extent. So the one that didn't have an extent was a path that didn't have an extent. The other was I'm not sure how you would describe that one. I think that one was the other was more of a wahi tapu. And I haven't discussed in detail that with the planning team who undertake those development checks, or the building consent team either, but my understanding is that it related to those scales as well. And so just leading on from that, I guess, is I've raised concerns around the use of the find site extents. I did have a conversation with Joe Ritchie around those find site extents, and I definitely understand the intent of them. I think, as Keith also highlighted this morning, I have concerns around the larger landscape that those sites sit within, and I think the hearing panel have definitely received a lot of evidence from the tangata whenua submitters in relation to the importance of those smaller find sites within the larger landscape. So just in relation to key issue 4 in the planning map section 42A, so I set out in my evidence, just for you, I guess for your ease, those tangata whenua submitters who have provided evidence to those amendments that have been suggested by Joe through hearing 14 as well. So that was all I had on the on the planning map section 42A. So I wondered, did you want to? I've only got a couple more paragraphs on the definitions section 42A, so I'm in your hands.
Let's just carry on, I think, so okay. We'll catch up.
So with respect to the definition section 42A, just had 4 key points to explore here, I guess. So you'll see in my evidence that I've just explored the definition for adjacent as well. Is it? Oh, not really explored. It's I guess just merely highlighted the use of or how adjacent to would be utilised, and particularly in regards to statutory acknowledgement. So I remember if we throw it all the way back, so back to hearings, we discussed it in quite a bit of detail, I guess, in hearings 1, 2 and 5. And so, yeah, it was just a query really around how the adjacent would be used in that regard. I know adjacent isn't necessarily defined in the RMA, and so I'm not aware that Te Koteitanga and the Council's planning team have discussed how statutory acknowledgement is applied in relation to that wording. So obviously you've heard from Liana this morning around the definition of treaty settlement land and the potential gaps and issues with the application of the definition. So I think listening to Liana this morning and based on her statement of evidence as well, that I think that some amendments could be made to that definition, or potentially, as Commissioner Coffin has suggested, perhaps just replacing it entirely with hapu and iwi owned land. So I haven't had the opportunity this morning to provide some potential amendments to the wording that I've already provided in my evidence, but I'm more than happy to do that after this hearing as well, and take further guidance from Liana on that matter as well. And I guess one thing I quickly noted it in my evidence was around the definition of papakainga. So I know we'll further explore that during hearings 17A and 15B, which are rescheduled for June, I think. And I noted there that I supported the wording that Jamie, I can't remember your colleague's name, had provided in the definition section 42A. I think it's much broader than the definition that's been proposed in the residential zones section 42A. I think it better reflects that integrated, that holistic nature of papakainga, rather than papakainga just being a brown residential development, to quote Rangi Kipper's words from a couple of weeks ago. And I guess, and also reflecting on Liana's kōrero just now around that collective ownership, and Māori land is often owned by, there's numerous owners. It is very complex, so reflecting that as well in the definition. And then I just wanted to highlight at paragraph 37 of my evidence as well. I did indicate that Te Koteitanga had no submission scope to the water bodies definition. And so on review of my evidence and the submission of Te Koteitanga and Ngā Hapu o Te Atiawa, I do consider we do have submission scope there, Te Koteitanga and Ngā Hapu o Te Atiawa. I guess I'm bringing this to your attention because I know that Federated Farmers did raise it last week. So, and I guess wanted to highlight that obviously a large amount of evidence has been produced by the tangata whenua submitters around the importance of wai, the importance of water. So I guess just wanted to highlight here that I don't want that, or in my opinion, that definition shouldn't be narrowed so much as to maintain the status quo, I guess, of the protection of natural and physical resources. So yeah, that beard status quo, I guess, that the tangata whenua submitters have submitted a lot of evidence about. But anyway, I will leave that in my older cousin's hands to explore that further because she heard the kōrero. So anyway, nō reira, that's me for today. So happy to take any questions.
Thank you very much, Sarah. We'll start with Antoine.
Kia ora, Ms. Makua. The first question is just in regards to this extent for fine spots, and I just wanted to see just whether you agreed or not, because it was a question I asked Mr. Holswish around. There seemed to be that there's two matters. One is providing certainty about fine site, what was the nature of that, particularly for landowners who are trying to work out, are they affecting that particular fine site or not? And certainly providing an extent does help with that. And so that was the one matter. And then the other one was, there's a contextual matter. Obviously a fine site is often going to be I suppose, perhaps evidence, but also a representation of other settlement or occupation or other associated sites or features in that particular area. So that brings into mind cultural landscape considerations. Do you agree?
Yes. I think there's definitely benefit in having the fine site extents where that's confirmed by hapu. And I guess as Keith mentioned this morning, that 50 metres would be the is what Ngāti Rāhiri would apply. But I guess when I think back to some of the other hearings, and that there is an opportunity for a nuanced approach for some of them to consider that cultural, that landscape that they sit within, definitely.
And just in regards to cultural landscape, because the council in our very first presentations we received was, there's work has gone on previously in terms of archaeological sites and identifying features and sites, to move to doing much more work on sites and areas of significance to Māori, work that's ongoing. And then a continuation of that work, then starting to be looking at cultural landscapes and the relationships between sites and areas in a landscape context. And I just wondered whether you had any particular views about should cultural landscape be looked at from the point of view of the what's the word I'm looking for, the combination of all of those sites and areas that have been identified, or more of a, I don't want to use the word top down, but more of a landscape perspective, looking at the stories and traditions related to the iwi and the hapu and the whānau, and from there that provides the context for which sites sit within. They're two quite different approaches, and I just wondered whether you had a view in regards to those.
Not a particular view. I mean, I understand that there probably is benefits to both, using both approaches, and I think that would probably definitely needs to be a discussion we would have to have iwi hapu wide. But yeah, not a particular view now. But thinking, I guess, that what I've presented this morning is that those fine sites sit within a larger, within that larger cultural landscape. So maybe the latter approach that you mentioned might be more appropriate. But yeah.
Thank you. My other question was, actually, I think that's been answered, actually, because we've had the benefit of Ms. Potu this morning. So my question's probably a little bit redundant. It was just around the use of the treaty settlement land term or another term that might be appropriate. These are my notes I already had from last week, so we've received your evidence. So I'm not going to ask you that question unless you had any further comments to make in regards to the iwi, land owned by iwi hapu vis-a-vis treaty settlement land.
Yeah, I mean, fully tautoko, the kōrero that Liana's given and her evidence as well. And again, just to reiterate, happy to explore what amendments to that definition could look like if that was helpful to the
Yeah, and I suppose my last one was just in regards to the relief you've sought in your appendix 1 is highlighted in red, and that's like adding the additional bullet point. Were you quite open to how that might be reflected? Because certainly Ms. Potu's evidence given to us, that seemed like that could be quite an elegant fix. Like the renaming potentially, rather than tinkering around with the text within the definition.
Yeah, and if Liana's still listening, we had a conversation this morning, and that there could potentially be issues with the use of claimant group, the wording claimant group, and,
yes.
And if you want, Liana might want to, if she is still listening, to just further explore that if you were comfortable with that. Sorry, Commissioner Dash.
Certainly, Liana, if you had any contribution there about the term claimant group and that definition. I'm not sure whether you got Sarah's appendix 1 Yes, okay. So go ahead.
I think just claimant group it's a term that could be extended or interpreted in a way that we don't intend, because claimant groups under treaty settlements refer to those who have lodged treaty claims with the Waitangi Tribunal, and that's an ongoing process. So, you know, groups can still file claims with the Waitangi Tribunal for contemporary claims, is what they're called. And so we don't want to get into a situation where we're unintentionally including a whole lot of groups that have Waitangi Tribunal claims and therefore technically are a claimant group. And so that's why I sort of, I'm comfortable with iwi hapu, because we know what that looks like in our landscape. But claimant group could extend beyond what we intend.
Certainly know from some investigations into customary title in the coastal marine area, you've had a number of claimant groups from one part of the country making claims on another part of the country, and they could be quite a few hundred kilometres distant. And in the ire of the local iwi there's a lot of what's the word, tensions and discussions caused as a result, just because of a claimant group putting in a letter or a claim. So I think that's probably a point well made. I didn't have any further questions, Mr. Chair, so maybe over to Kit.
Thank you, Antoine. Yes, Kit.
That's actually an interesting discussion. Again, the power of terms, isn't it? Okay. So I didn't want to talk to you much further about that. What I did want to talk to you about was your paragraph 10, Sarah, if you've got that there. This is this scaling issue. And I was just wanting, if you haven't picked a winner, if I can put it like that. And I don't know, because Ms. Gulliver has suggested 5 different sort of options to resolve this, set out in the 42A report. And I'm just wondering whether you had gone through those and had a view on what you would see to be the most effective and efficient way to deal with this issue.
I didn't pick one for that reason, because I didn't know. In my mind, I didn't know what was the best option. I know that I think I would have concerns about the layer being turned off entirely. So I think it definitely does need to stay on. And I guess for me, based on my evidence, this is particularly in relation to sites and areas of significance to Māori. And that issue. So I guess thinking about, I think wholly about myself and using the planning maps now, is that I am really familiar with it. So I'll know to zoom in and zoom out and move the plan around so that I can see where, there are other mapped or scheduled sites and areas of significance to Māori. But for a plan user, I know that we've had instances where they haven't been picked up. So I guess the sooner the better for SASM to be highlighted to a plan user. Sorry, I really just beat around the bush there trying to answer your question.
No, that's good. I think the key, the really helpful steer is that you don't see turning off the layer is the solution, and I don't think Ms. Gulliver sees that either. So that's good. There's at least a common view there, and I think your observation that, and I guess it's to borrow Keith's analogy, the longer you wear these socks, and you get to know how they feel, the more knowledgeable you actually become, and the more you are able to access the information you need. And so, to some extent, the first time the virgin user for this plan opens up is really got to give them at a high level in a visual way all of the stuff they're going to have to navigate through. So, and then they're going to dive down to differing levels of detail based on what they're actually looking at resolving. So no, that's very helpful. Thanks, Sarah.
Cool, thank you.
Okay, you're done?
Yep, thanks. Yeah.
Okay. Sarah, just picking up on Kit's question there, is this, in your mind, the issue about the scalability and whether you can actually, everyone looking at the E-plan can automatically know that there's something there? Is it more about you being tired of people saying, look, we didn't know, having to try and play catch up, whereas if it was clearly evident from whichever way you looked at the planning maps that there was a site that needed to be sort of thought about, is that the issue, or is it? It's not about the legality, because anyone that's ultimately, if it is in the plan, it is in the plan, whether you turn a button off or not.
Yeah, not the. I'm not so concerned about the legality of it. I mean, these two retrospective consents I've highlighted, we're working through that process. And yeah, I think it's ensuring that looking at the entire strategic direction of the plan is that we're not only, we as a Māori, iwi hapu aren't going to be only engaged on sites and areas of significance to Māori or applications that affect them. We're going to be, it's likely we're going to be engaged on a significant number of applications now. So it's that upfront engagement and people understanding how these sites, people plan users understand these sites and areas of significance to Māori form part of that bigger picture for hapu iwi Māori.
Okay, no, that's as I thought. I just need that confirmation. There are some other couple of areas of evidence which I think you've referred on to Maria because she was listening in on Friday, but there was these couple of areas. One was some legal submissions from Kāinga Ora from Bell Matheson about the terms adjacent and adjoining. I notice in your paragraph 22, 23, you're looking at how the term adjacent might be defined in terms of being near SASMs and historic heritage, and I think Bell was suggesting that those terms are so similar they should be perhaps be merged and B, made really clear that it doesn't have to be right beside, but there needs to be some spatial scale to define the nearby aspect of those terms. So that's one which I know Mario, that we had quite a lot of discussion about that. May talk to us about. There's nothing else you want to add other than what you've got in your evidence?
Yeah, just that really. I mean, when I first read the definitions chapter or section 42A, I thought it was going to be quite lengthy, but it was good to know that we didn't have to traverse everything that had already been traversed already. So yeah, that's that really.
And look, on the other point you've raised about the water matters, we did have quite a long discussion with Federated Farmers, with Jamie, really around those definitions, which had been, as you say, we had a lot of evidence on prior, and certainly we were asked whether we were comfortable by the staff just re-looking at this in the light of that new evidence that's come in from Federated Farmers, from another witness. And we did say, yes, we were comfortable just being thought out again in the context of this hearing and this right of reply. And it does mean we're not litigating here. The term was, is it okay to relitigate these things? I think this is part of the one hearing. We grouped into topics, but all these things are interrelated. So if there was some further dialogue needed at a witness level about some of those matters raised by Federated Farmers, I've just signalled to Jamie and the staff team that iwi have certainly had views, as likely other submitters may have as well, that we just can't come along for a second bite and just open the whole thing up again without respecting the important process aspects that some of those matters have been dealt with already. But on balance, we thought with the importance of the water issues as between the regional plan and the district plan, just a bit of reflection might not be a bad thing. So we'll hear on the right a reply from Jamie about whether she's comfortable with the evidence we've got, or whether she does want to advance any other discussions.
Yeah, sure. Just on the relationship between the regional plan and the district plan, as well as so we, Ngā Iwi o Taranaki have actually just advertised 2 roles for policy planners who will focus just purely on Te Manarotiwa. And they will, whoever those planners are, they'll sit within Te Koteitanga o Te Atiawa. But will have a definite relationship, obviously, with the regional council. So they'll be preparing, or assisting other planners within the regional council on the regional freshwater plan, in the new natural resources plan, and the regional policy statement. So it's all very exciting, and yeah, and in a really good space moving forward for us.
Yes. Okay. Well, yeah. So my point was really, if there's, we're well aware that these matters have been dealt with in previous hearings. If there's some further thinking going on, we just wanted to make sure, as I said to Maria on Friday, that iwi are involved if the staff do decide they need some further assistance. Thank you. And Sarah, thank you for your kind wishes before. This piece has not been easy for me. It's I had hoped that it would be just a week and I was back into it, but it's taken more time. I think this affects different people differently. So I'm pleased to be back in dialogue. Okay, so thank you for that. So Marty, I think we're working with you. So you've had given us your evidence. We've read that. Just over to you to present the main points. Thank you.
Cool. Thank you. Mō tēnā tātou. Yeah, thank you again for the opportunity to speak to my evidence and to the submissions of Te Kahui o Taranaki iwi. So I'd like to just touch on a few points that I've outlined in my evidence. So the first one being the scales for SASM. So I appreciate that plan legibility is a concern for council, and that this is because of the sheer number of SASM. This is one of the main barriers to enabling the visibility of SASM at all scales. However, so I understand it, but I retain significant concerns that SASM will be negatively impacted if they're not visible on the plan. And so, as Sarah mentioned, she's aware of a couple of developments within the Te Atiawa Rohe. And similarly, I'm aware of several, of at least 2 instances where within the Taranaki Rohe, where development has been approved via the building consent processes, which impacted on SASM and would have required resource consent. And in both of those circumstances, neither the developers nor council staff identified that
SESM were impacted by those developments. And from my understanding, it was due to the scale issue of the plan that contributed to the non-identification. So however, following Ms. Gulliver's presentation last week, I went back and revisited the options and looked at different properties to try to, just review those different options, because in my evidence, I said that I preferred option 5, I believe it was. And so in terms of my my position now regarding the scale of SESM in my that I prepared or that I've presented in my evidence, I maintain that there is an over-reliance on the left-hand panel to identify SESM within properties. But my opinion regarding the appropriate option for the scale has changed. So I consider that option 1, where SESM are visible at the 1 to 8,000 scale, would capture most SESM. But I also echo the concerns of Matua Keith regarding that SESM and other layers should be able to be toggled on and off at any scale in order to aid plan users. So I think that I don't think that there should be just one blanket approach for SESM, particularly because of the impacts that have already occurred on SESM under the current mapping and the current scales. So I agree. I now agree that option 1 would capture a lot of the SESM, but I still think that there should be more functionality for people to select at what scale that layer could be turned on. If you're looking at a specific property from a higher scale, that there should be the option to turn on a layer. How that works, I'm not a GIS person, sorry, so I can't offer any actual insight, but in terms of plan user functionality and making sure that SESM are visible and able to be seen when looking at a whole property, I think is really important to get that engagement, early engagement and early awareness for plan users that there are these significant sites that need to be considered. The second other mapping matter that I'd like to address today is the 5 metre extents on the find site SESM. And as I discussed in my evidence, these sites are part of a wider cultural landscape, and I don't consider it appropriate for extents to be applied to these sites, to the SESMs, without the cultural expertise of Hapu. So from an archaeological standpoint, I can appreciate that a 5 metre extent would capture the archaeological evidence attached to that particular find site, but I don't think that it's appropriate for a site, an area of significance to Māori, to be limited to 5 metres when it's part of a wider cultural landscape. And so the example that I included in my evidence was of SESM ID 69.
Aria, could you bring that up? Have you got the facility there to bring up? I think it's on your page 4. You've given us that example.
Yep, I'll just share my screen. So can you see my screen?
Yes, we've got that. Thanks,
Okay.
Maria.
So site ID 69 is a fire feature at the end of Lower Timaru Road, I believe it is. So, and looking at the map within the Appendix 1 of the Section 42A report on mapping, yep, it looks fine. It's a fire feature. There's an extent, a recommended extent put around it. But I've included a wider map here of the surrounding area. So here, if you can see my cursor, that's where site 69 is. It's a fire feature find site. And then there's Tupā site here. There's a redoubt up here. There are also a number of known but unidentified or non-mapped SESM within this area as well. So there's another Kainga site within this kind of area. And then along the coast here, there are a number of reefs of Tauranga Ika and Tauranga Waka, which is waka landing sites and fishing channels, and Mauri Kohatu, which is Mauri stones along this area of the coast, which are identified elsewhere within like the proposed regional coastal plan and within the Taranaki iwi deed of settlement. So they're known but not mapped in the PDP. So there are, yeah, while this one fire site here may be I guess a limited area of is impacted by the archaeological evidence. I think it's inappropriate to put a 5 metre SESM extent on the SESM when the cultural landscape extends right throughout this area, and any development within this area in here is likely to unearth additional evidence of that cultural landscape. And so I don't, especially because this 5 metre extent has not been approved by Hapu, and I don't think that would be consistent with the way that Hapu view this particular area, acknowledging that I am not a cultural expert for Hapu, but from my experience with dealing with Hapu regarding Haurangapā and some of the other SESMs within this area, they're viewed as all connected and part of that wider cultural landscape. Yeah. Did you want me to stop for questions now while I've got this up, or are you happy for me to move on?
Yeah, no, I think that would be good, because I think that context of both the specific plan and the wider landscape is a good place to stop, to see whether Antoine or Kid have a question.
Yeah, I had some questions for this particular part, but I think you've answered them, Maria, and just in terms of what are you thinking. And I think the important point, which I hadn't identified really clearly, and you've made that very clear, was around requiring tangata whenua input into the extent. And so that's something we heard about in the robustness of the work that's been done for the SESMs that have been identified and their extent in the SESM section of the plan. So it was a good reminder in that regard. And I just wondered whether, just in your experience, by either having the extent, which might be identified for, in this instance, a fire scoop, which might be quite a finite area, as opposed to perhaps where you don't have the extent and you've got a wider consideration, if there was a resource consent required, or people, the landowner was looking to see whether a resource consent was required in the area, could either of those trigger an assessment of some kind or a conversation, or would if you've got the extent and it's outside the extent, does that presumably then mean that the local hapu or iwi won't be contacted? But if there was the wider buffer area, then you would be?
Yeah, I think it's more, so it would trigger, there's a trigger for anything within proximity of 50 meters of that extent, which if someone were to, if they were to take that 5 meter extent and then 50 meters from that, the assumption would be that, oh, I'm all good, I don't need to consult with hapu because I'm outside of the trigger area.
Yes.
And even if they were 55 meters away from that point location where that fire pit was, the likelihood that they're going to uncover something is very high. And so we would, yeah, I guess the risk is that unidentified SESM or additional archaeological and cultural evidence is damaged as a result of development where people think, oh no, I'm 55 meters away, there's nothing here.
Yes,
Yeah,
because we're talking about a point in time of the knowledge that's currently,
Correct.
so yeah, no, I appreciated that. I didn't have any other questions, Mr. Chair.
Thank you, Kit.
I didn't have any questions, Maria.
Thank you. Okay, well, I don't either. I think your evidence is clear there, and thanks for bringing those up, Maria. So we just carry on with your next points.
Cool. So then moving on to the definitions, I'm largely accepting of the recommendations from the Section 42A report. However, listening to Ms. Potu and reviewing Sarah's evidence, which I didn't do before I submitted mine, I would 100% support the position of Ms. Potu, and yeah, Te Kāhui o Taranaki would also share the position of Te Kotahitanga o Te Atiawa regarding the limited land available and returned through the settlement process. And I guess the role of post-settlement governance entities regarding the use of settlement monies to, I guess, to reassert the presence of tangata whenua on the land within their rohe. So I would echo, yeah, the amendments sought by Ms. Potu, and happy to work with Sarah on presenting some updated amendments on the definition of treaty settlement land or iwi hapu owned land to address those concerns raised by Ms. Potu. And the second definition matter that I'd like to address is the natural water bodies and the amendments sought by Federated Farmers in their evidence to this hearing. So as Sarah's mentioned, tangata whenua submitters presented a wealth of evidence regarding water bodies to hearing 5. And I'd particularly like to remind the commissioners about the evidence of Te Poihi Campbell regarding the whakapapa of wai. And so as Te Poihi mentioned in his evidence, all all water, all Y is connected, and all Y is significant regardless of the state or stage within that manifestation that he described. So this is whether water is within a main awa channel, whether it's a tributary, a wetland, or a stream that has been piped or is being used as stormwater infrastructure. All of these water bodies are interconnected, and there are kaitiaki associated with all of these areas of Y. And so as the tangata whenua submitters outlined in the water bodies hearing, the different treatment of different water bodies or the different states of water is inconsistent with a Māori worldview. And I would reiterate this point in response to the evidence presented by Federated Farmers to amend the definition of a natural water body. Wetlands in particular are hugely significant for tangata whenua and are valued as a resource and as a kai source and as a location for spiritual and cultural practices. So Taranaki iwi actually were renowned throughout the motu for their high quality flax products, and flax grew particularly well in Taranaki because of the many wetlands throughout the rohe, which supported a wide variety of different species of harakeke and allowed for the active, I guess, cultivation or horticulture of harakeke, of flax. And so currently, well, in 2013, TRC issued a report noting that only 8.1% of the original wetlands within Taranaki are remaining. And Stats New Zealand reports that between 2012 and 2018, a further 16 hectares of wetlands were lost within Taranaki. And so for Taranaki iwi, for descendants of all 8 iwi in Taranaki, Muru me te raupatu resulted in a loss of land and a loss of resources, a disconnection with the significant places, and a loss of a source of their mana. So they were really well known for these prized flax products, for the woven kaitaka, which is a kind of cloak. And following the taking of the land, this was gifted to the soldiers who perpetuated the Muru me te raupatu. And many of the wetlands were drained and huge areas of vegetation were cleared to make way for farming. And now the descendants of the recipients who received that land, who have benefited and profited from the land for decades, are now seeking to amend a definition within the PDP to allow further destruction and removal of wetlands for further economic gain. Tangata whenua submitters have been clear in previous hearings and in the evidence to previous hearings regarding the importance of Y and of wetlands. And as a Māori resource management practitioner, I would oppose the amendments to the natural water body definition put forward by Federated Farmers that allows for the removal and destruction of remaining wetlands and former wetlands which are re-establishing, regardless of whether this re-establishment is intentional or naturally occurring. And I'm happy to work with the council report writers if they require further clarification on the tangata whenua point of view regarding water bodies and Y and wetlands. But that was all that I wanted to cover of my evidence today.
Thank you, Maria. Antoine, did you have any follow-up questions on that additional evidence?
No, I didn't.
Okay. Kit?
Yeah, thanks, Maria. I just wanted to clarify one point. Paragraph 14 of your statement You refer us back to the views you expressed about mapping of water bodies where esplanades are required. And you talk about the evidence you gave at hearings 5 and 9. I'm just a bit confused by the last sentence there. You say you consider that if the goal is pathway or access connectivity, this is best reflected through the method of public access corridors rather than esplanade strips. My understanding was that the public access corridors are an indicative location of access that may or may not bring with them yet the property rights for the public to go over them, but that to gain the property rights, there needs to be the mechanism to get either an esplanade strip or an esplanade reserve. Is that your understanding as well?
My understanding, but I'd note that this is in response to the mapping of esplanade strips as opposed to public access corridors. That was my
okay. So, all right, I get it now. So you're saying that in terms of the preferred locations for strips and reserves, etc., the best tool is the public access corridor overlay, and then whether an esplanade reserve or strip is taken, are you suggesting ought to be linked to the location of a public access corridor?
Correct. Yes.
So that's a slightly more nuanced approach than what we were talking about with Ms. Johnson this morning, for example, which is quite a black and white proposition. I know that was more about whether it was a strip or a reserve. Ms. Johnson is supporting the notion that we use the schedule 9 for this location. So if we were to put on one screen the current network of proposed public access corridors as shown on the map, and on the other screen we were to put the Schedule 9 water bodies, would they be the same?
Not sure.
Okay, all right, well that's a hard question because there's a lot of stuff in that schedule. I'm just interested in, because what we're talking about here is what's the best mechanism to identify how we create these corridors. And on one hand, we've got this public access corridor network that's already mapped as an overlay. And then on the other hand, we've got this schedule of priority water bodies, which are now being co-purposed to some extent as those water bodies where we might like to see these reserves or strips. Do you see the two as doing different things or the same things?
It's both. So I think that traditionally esplanade strips and reserves have been used to provide public access.
Yeah.
And so I know that esplanades are not solely for that purpose, but that's predominantly how they've been used. And so my view is that often esplanade strips are taken and thereby provide access where that's inappropriate. For example, along water bodies where there are SESMs, where access should not be provided. And so if we're taking esplanades for the purpose of access, that is best reflected through public access corridors, not esplanades in general. So I think that both.
Okay.
Yeah.
No, that's helpful. Yeah. Yeah. Remind me again what your position was on the mapped public access corridors in the proposed plan. Were you generally comfortable that if they were extended or created by way of a reserve network, that we wouldn't be getting into potential issues of conflict with SASMs? Or is it not at that level of detail that you're able to give us advice on that?
Yeah, not at that level of detail. And predominantly a lot of the public access corridors are within the urban areas and are they coincide with the priority water bodies of the operative district plan. So whereas Esplanade strips, we're across the board on all water bodies. Yeah, so I'm not aware of the level of detail for, especially for the SASMs along all of those public access corridors. But my understanding is that while the public access corridors are indicative, when it comes to that taking of where the public access corridors go, SASM and Waihi Tapu and all of those things are part of that consideration.
Okay. Mm. Yeah, okay. I just got going through my head as a sort of a bit of a nervousness that the aspiration of some of these public access corridors might not be able to be given fruition potentially if at that level of detail we've got some SASMs or Waihi Tapu that are right where the access is planned to go. But I don't think we can answer that. I guess that's something for what happens when that time comes, doesn't it? Yeah.
Yeah.
Okay. All right. No, that's helpful. Thanks, Stephen. I didn't have anything else. Thanks, Maria, again.
Yeah, Maria, I just have one line of questioning. It's about the water body issue. You would have heard the discussion on Friday. This is a complex area of law and practice at the moment. I think you'd agree with that. And we did give license to perhaps reopen some of the discussion on Friday, but perhaps just for the staff, and I'm interested in your view too. The definition of water body was actually supported by Federated Farmers in their submission as it was. So I just got in my mind that we're going to have to be pretty careful if we are looking at any of the changes that Mr. Matic was suggesting, just back to the fundamental area of scope. And I'm sure we're going to be hearing about this in the right of reply. So Jamie, that was just a heads up. And the other thing I haven't done, I can't recall exactly the position of Federated Farmers at that's hearing 5 on these matters. So you just sounds like your position is you're standing by evidence on these matters in this definition in hearing 5. And if there is any reason the staff might want to revisit this and any advice to us, you definitely want to be at the table if there were some further discussions.
Yes.
So that's
Yes.
your position.
Yes. Thank you.
Yep, thank you. Just to clarify that. All right. Well, I think that's everything in terms of evidence for this hearing. I appreciate your assistance again, Maria.
Thank you very much. Kia ora.
Kia ora. Ashley, Jamie, we're at 12:30 now. I'm thinking that we should take an hour's break for lunch before we have your verbal right of reply. Does that suit you? Okay.
Yes, that's fine by me.
Bit of a recharge, so we'll reconvene at 1:30 p.m. Thank you.
Thank you.
Here we go. Hope you've all had a good lunch and a nice break. So we're now on to verbal right of replies. Ashley, are you going to kick off?
I sure can.
Okay, thank you.
Okay. All right. Okay. So, just for reiterating, my name's Ashley Gulliver and I've authored the section 42A for the mapping topic. So this is my verbal right of reply, and based on the written and oral evidence presented by submitters today and on Friday. So the questions asked of me at the hearing, I'll just start there. The panel raised questions around security of ePlan information and how GIS data is locked down so it can't be accessed or altered. So just in response to that, during presentation time at the hearing, I spoke about the ePlan versioning and that each version is published and a standalone record of the ePlan as it makes its way through the plan making process. So I talked about record keeping that's built into the ePlan software that ensures a change to a layer is stamped and that plan text changes have a really comprehensive record history. So while there's only a small number of people in council who are authorised to make changes to the GIS of the service or the ePlan, I think it would be beneficial to explain the formal process that the council follows when any changes to the planning maps are made. So I wish to include that as part of my written right of reply, and I think that'll help for full process transparency as well. But getting into the issues, these have just been grouped as per the issues through that have been raised in my section 42A, with the first one being just issue 1 with ePlan cartography and functionality. So just putting some context around it, Mr. Keith Holsworth was speaking on behalf of Ngāti Rāhere, raised some concerns at the hearing around the property-based nature of the ePlan, the inability to click on map features that are not on properties, the inconsistency with the NPS requirements, and some GIS limitations of the ePlan. So I really appreciated this discussion generated on the inner workings of the ePlan, and I can see that there is some things for myself to consider, both within the ePlan, but the processes that sit outside the ePlan that link in with implementation and comms planning. So just in response to some of those things, whilst I note that there is a range of GIS platforms and map viewers that can provide a range of additional functionality and features for a particular data set that they're made specifically for. But this slightly differs to the e-planning GIS service that's delivering planning information in a district plan context. So on Friday, I spoke about the inception and the development of the draft digital district plan in 2018, which was founded on that multidisciplinary approach with a project team bringing together a range of experts in GIS, lawyers for plan legal robustness, the user experience advisors, graphic designers, and then professional policy and consent planners and software developers. So today we talked about the appropriate level of detail and simplification that the plan should have. So a fundamental principle of the ePlan has always focused on the end plan user and making planning information readily available and accessible for the community. So the key user story for future plan users has always kind of focused on citizen-led inquiries that tailors planning information to individual properties so that the plan user can answer simple questions like, what does this mean for me and what can I do on my property? What are the special features or items I need to be aware of, and what are the things I do and don't need consent for? So that's also a reason why we've incorporated a traffic light system of colours in the rules tables for green for permitted, and then through to the red non-complying activities. And that follows through with the range of graphics to make the e-plan easier to understand as well. So I'm still of the view that the e-plan is pitched at the right level for all our community. While the National Planning Standards doesn't require e-plans to be property based, I'm of the view that the approach of the draft and proposed e-plan platform provides an appropriate and effective way to deliver the requirements of the planning standards and allow our community to access and interact with planning information. While I'm fairly certain that we do comply with all aspects, I will confirm this with my written right of reply in terms of definite alignment with that NPS requirement. And I also think that there's some great ideas raised about improving processes outside of the plan, including direct contact avenues for reporting e-plan faults and issues, and a range of kind of user helpful information avenues that sit along along the lines of chatbots, FAQs, and user guides. So that was great discussion as well today. Just moving on to issue 2 with the scale ranges. So just putting back some context in, that was about the submissions received in relation to the overlays, and particularly in relation to the display of SESM, and the e-plan scale range settings determined which Zoom layers, particular layers would turn on or off. And again, they were based on user experience, so that when a plan user zooms in to the planning map, that more site-specific information starts to show. As indicated in the section 42A, I agree that the scale ranges for SESM do have limitations in displaying information for some situations, and that's been highlighted in submitted evidence at this hearing. So essentially the discussion of this issue centres on again, balancing the user experience with appropriate visibility of labels. And I do kind of recognise that we may not 100% be able to configure it perfect for all scale ranges and all types of properties. I also realise I've left the recommendation rather open for the panel, but I would like to undertake some further testing of raising that scale range to a 1 to 8,000 as per my preferred recommendation. I also thought about a safety net sitting internally with council, so that all of those buffers that relate to, the setbacks or triggers can be mapped, and then so staff can do that double check with this layer before finalising anything, and just as a final check for nearby setbacks before finalising consents. A drawback of that is, of course, it's removing it from one source of the truth as the e-plan, so there have to be really clear update requirements internally to make sure that that's never out of sync with the one source of the truth.
Actually, I think we certainly would appreciate a recommendation from you on the scale ranges. You're so intimately familiar with it, and I think we're down to option 1 or 4. And Maria, perhaps, or today, sort of thinking more like 1, but just your recommendation to us, even if you say it's just a fine call, but on balance, your professional opinion is this. That would be good.
Yes. Yep. In the written right of reply or today?
In the written right of reply. Yeah.
Certainly. Okay, just moving on from that to the issue 3 in the report, which was about SESM sites needing minor extents added. So this was as part of previous considerations of the SESM chapter hearing 14. And the reporting planner there advised that fine sites and similar types of sites with small discrete footprints such as fire features, and that could be identified as having a small 5-metre circular extent put around them to avoid triggering that 200-metre rule for identified sites. And this approach was supported by expert archaeologist Daniel McCurdy. In applying this approach to the planning maps, table 6 of the mapping report identifies and itemizes 50 find sites. So just in response and considering the submitted evidence on this issue, Ms. Jo Ritchie and I have, in short, agreed that the 50-metre buffer should only be applied to the archaeological sites, and that it should be removed from sites that are the SESM sites or the dual arc SESM sites as a more appropriate approach. This is in recognition that the identification of appropriate site extents should be informed by tangata whenua, and to be considered on that case-by-case consideration of the wider cultural landscape and the consideration of activities to each site as required to determine what is appropriate in the context of those areas. So if we were to apply that amended officer's recommendation to table 6, this would reduce the number of total sites that are just sole archaeological sites without the SESM component to 18 sites that would have that 5-metre buffer. So I'll redo that and update that list to be included in my written right of reply as the amended recommendation there. Just moving on to issue 5, indicative transport roads. So we received submitted evidence from Deborah and Barry Salisbury opposing the indicative local road across 11 Oakwood Drive, and received traffic engineering evidence by Mr. Ian Steele of BTW. And their recommendation was to reject the recommendation of the 42A to retain that indicative local road. And just in response to the discussion that we had there, I've sought comment from Council's roading team and consents relationship manager, Ms. Rowan Williams, and understanding that current development in the wider area. And of course, also included Jacob Senna in those as the reporting officer for the transport chapter. So as indicated in Mr. Steele's statement of evidence, the connection between Keter Road and Portland Drive is inevitable. And from speaking with council roading and consenting departments, you know, there are those staged subdivision and development plans submitted to council connecting down, which through that hearing, through our hearing, has been known as the Maya development. So we also talked about, panel discussions also talked about being strategically aligned with those subdivision plans to the north. And in light of the discussion and evidence presented at the hearing, I've asked council transport team to give a preliminary thought to whether an indicative pathway connection providing walking and access is appropriate. So while I have preliminary advice from council staff disagreeing with the engineers, BTW's engineers' view that the indicative road would be a rat run, as the design intention would be that it would be a low speed traffic calmed environment similar to the rest of the Maya subdivision local roads. They would indicated that they would be comfortable with a pathway or cycling access, which when they say access, a legal 5-metre road width only used for walking and cycling to enable access from the Maya subdivision to the school. And somehow including that the Oakwood cul-de-sac would need to be at the back of the boundary of the Mangaree school to service potential lot behind it. So that's kind of similar to the extent in the operative district plan. So I will need to do more investigation on the staging and timing of some of that Maya subdivision land, and will provide a more fulsome response to that in my final recommendation built into the right of reply.
Just on that, Ms.
Yeah.
Gulliver, on the plan for memory was handwritten first stage only. So I'm just assuming, was the approval of that subdivision for the first stage only of the many stages that we saw on it?
I wasn't able to get confirmation of that today. I was hoping to get confirmation of that before lunch, but it hasn't come in. So that's what I want to make sure I get that confirmed, the timing and which ones are actually approved as part of my response. Yes. And then just moving over to network utilities, from First Gas's original submission that sought the amendment to planning maps to include above ground infrastructure based on their locations and coordinates as part of the gas transmission network. So the office's recommendation on the overall overarching approach to the inclusion of the above ground assets were provided through that network utilities hearing 11 and the office's right of reply. However, listening to the discussions this morning, there was a misalignment that needed to be addressed between the mapping setbacks of the assets as First Gas envisaged and how that has been translated through the network utilities right of reply and then across to the planning recommendations. So just a couple of points in response to that this afternoon. So we've got the First Gas shape files now, and as directed, I'm happy to work with both Nicola at First Gas and Jamie Cannon to align those mapping requirements. And I'd also just like to recognise and thank Nicola for pulling all of that information together prior to the hearing, so that we can get that mapping corrected through that right of reply process. So I just wanted to thank you for that. Over the lunch break, I've spoken to Jamie, and we were thinking it may take maybe 3 weeks just to confirm the First Gas mapping and give given the discrepancies in the data that they have provided. So I'd just like to flag if the panel are comfortable with an extension for the mapping right of reply to 3 weeks, due 23rd of May, as I also realise our GIS expert has the rezoning and other mapping corrections work on at the moment as well.
That's fine. Just take that as approved, Ashley.
Okay, thank you very much. And the last thing I just wanted to raise in my verbal right of reply was under issue 10, which was other planning maps. Helen Johnson's original submission sought the requirement of esplanade reserves to be identified in urban areas on key water bodies identified for public access purposes. So Ms Johnson's submission point was split during the process of summarising, and one coded to planning maps and the other coded to the subdivision effects standard, which was the subdivision S9 requirement for esplanade reserves and strips. So I note that this issue has been partly discussed in previous subdivision hearing 9, as well as under water bodies. So I guess what was unclear is how the esplanade reserves and strips should be notated and whether there's a need to map them as the approach in the operative district plan, or whether the public access corridor in the proposed district plan, that network provides a strategic approach, and whether additional mapping would result in a duplication. So I note that the plan needs to make sure that it's clear when council will take either a strip or reserve, and the PDB has deliberately built in flexibility in this approach that was proposed. However, I acknowledge that the issues raised by Ms Johnson and that discussed today. So there may need to be some clarification in the rules, as it's possibly not as clear as it could be, and I'd like the time to explore that further, and we'll respond to that in my written right of reply and work with both Ms Denise Young and Nicola Lawrenson on getting that clearer. And just in terms of next steps, a written right of reply will address outstanding matters as I've referred to above. So thank you.
Thank you, Ashley. We'll see if there's any questions of clarification from Antoine.
Hey, thank you. That actually covers my questions I had, I think. It seemed to me that it's quite an elegant response from Ms. Jo Ritchie and others in regards to the archaeological sites. As I had written a note for myself, that was potentially an option, and you've already covered that off, so just really appreciate that. I was wondering if there was any further feedback in regards to the water body, natural water body submissions of Fredo farmers, and our chair had mentioned that just before the break. With you, oh, sorry, I'm getting myself. Sorry, you're looking as I was talking. I'm going. You raise that because that's not your role to raise that. That's the next one. So I'm going to hold on to it. I don't have any further questions, Mr. Chair.
Thank you, Antoine. Kit.
No, I just look forward to you thinking through those issues and getting them to us in the written right of reply.
Thank you, Kit. Actually, I have one question. It's about Keith's suggestion for practitioners or anyone being able to sort of turn on and off the layers as a functional addition without having that function. Have you thought about that? Is that
I think it's either one or the other. It's kind of we go down the route that plans like Porirua have, where it's completely all decided on what the layers that the plan user wants to turn on, and then they're on all the time so that the viewer can view at any scale. So it would be, I can check with our software provider if there's anything that I'm missing functionality wise that kind of we can use for having that user experience zooming on, and potentially looking at anything that they can customize on that planning maps tool side. But as far as I know, it's kind of we either set the zoom scales and have it set as part of the ePlan function, or we have it completely toggleable at any scale.
Okay, well, if you could just check on that, because I think there were sort of some good thoughts here. And the other one about the ability to access the service information, I think your evidence is that we can't, there's not a one-stop shop for having a system where that can be turned on as part of the ePlan, the services, GIS.
Oh, in terms of like the reticulated services and that. We can always add all types of layers. I had a look at other councils, and I think I came across one that had reticulated services added on as a non-district plan layer on their layers option. So it can be done, but just the fact if it would frustrate people that they couldn't click on mains to find out more information about them, whether that would kind of annoy them if they couldn't interact with it like they can with the other council mapping services.
Okay, so
it's viewable, but whether they wouldn't be able to interact with it like they can click on things on our other kind of open data services.
Yes, Keith, if you're listening, any thoughts on that option of actually being able to view it but not necessarily interact with it in the ePlan?
Yeah, I don't think that would work because you really need to know what is there, and if it's a 122 millimeter water main or a 50 millimeter ring main, or what's the size of the sewer, how deep is the sewer, all that sort of information needs to be identifiable. So it appears as though that can't be done on this new system.
Okay. Yes. Thank you, Ashley. Maybe if you can just confirm that to us in your order reply, just closes the loop for us. And thank you for your assistance today. I know you're not feeling that great, so you've done pretty well. Yeah, well done.
No worries.
Okay. Jamie.
Hello. All right.
Hello.
So just to reiterate, my name is Jamie Cannon, and I am one of the co-authors of the Section 42A report for definitions on the proposed New Plymouth District Plan. I prepared the Section 42A report with Lucy Deverill, who was unfortunately unable to attend the hearing due to illness. This is my verbal right of reply based on the written and oral evidence presented by submitters on the definitions, and I intend to expand on these matters in my written right of reply. Many submitters who provided written evidence are in general support of the recommendations contained within our Section 42A report, and so for these submissions we maintain our position and generally stand by our initial recommendations. My verbal right of reply makes comment on some of the more specific matters raised by submitters, including the key matters that remain in contention. Firstly, the definitions of multi-unit development, self-contained and sleep out. Kāinga Ora has sought that the definition of multi-unit development is adjusted to align with the evidence presented at the residential zone hearing, to allow 3 residential units as a permitted activity in the medium density residential zone. Kāinga Ora also seeks that the definitions of self-contained and sleep out are deleted from the proposed district plan because these terms are self-evident and accounted for in the definition of accessory building or residential unit. We understand that Kāinga Ora has also sought that the term sleep out is removed from the residential zone provisions, meaning if this request is accepted, then the terms self-contained and sleep out would no longer need to be defined. I understand the points being made. However, our recommendation on these submissions is reliant on our understanding of the reporting officer's recommendations on the residential zone topic. Since a coordinated recommendation is necessary and the residential zone hearing has been deferred, we recommend that these submissions are deferred and addressed in the residential zone or the sweep up or plan integration hearing. I just want to get an indication from the panel whether this is acceptable to you.
I think that's the only logical course, Jamie.
Yep.
Perhaps picking up in the sweep up. I'm just trying to think about, there's a right of reply process for the residential zones, which we'll need to wait for, and then you'll need to wait for that. So we'll be into probably late June anyway. Yeah, I think if you can probably just carve that out in your right of reply as something, and just let us know how you're going to deal with that, or the council team's going to deal with that. That's the best thing to do. Kit, did you have any thoughts on that?
We've already got the reports for that, and we've read all of the evidence. So are we assuming that there might be an addendum to the report to deal with these issues if we get it in the residential hearing in early June?
We'll hear some other evidence, I presume, from Kāinga Ora on these matters. So there might be some more oral.
Yeah, I'm just conscious our recommendation will be heavily reliant on Mr. Campbell Robinson's response to Kāinga Ora's requests on the residential zone. So without without that information, I guess his recommendation may change through the hearing process as well once he hears Kāinga Ora's evidence. So I feel like it would be preemptive to make a recommendation on those matters now without the residential zone evidence being heard.
So we're better to wait. This will be dealt with in the sweep up then, is what we're saying. Is that right? Yeah, okay. So we just got to hope.
That's what I'm suggesting.
Yeah, okay. All right. Yeah.
Cool.
So we've got to hope that the reporting for the sweep up chapter is after the reply on the residential chapter.
And it should be, because that's sort of
should be. Yeah, it should be.
Yeah.
Cool. All right.
Cool. All right. Thank you. The next one's terms are adjacent and adjoining. Kāinga Ora has filed legal submissions on these 2 definitions and considers the defined terms do not add any clarity to plan users because they have a common meaning that should be adopted without needing a specific definition. I understand the points being made. However, my initial view is that there is a clear distinction between the two defined terms, and these are used in different contexts throughout the plan, as demonstrated in our Section 42A report examples. These definitions provide plan users with clarity and certainty and assist with the effective and consistent application of the provisions. I will expand on these matters in my written right of reply. In terms of reverse sensitivity, Kāinga Ora has also filed legal submitters opposing the proposed definition of reverse sensitivity, either seeking that it is deleted or an alternative definition is used. I acknowledge the points being made and agree that the terms perceived environmental effect and potential for within that definition are not necessary. However, I am mindful that we received 13 submissions in support of the proposed definition, with several further submissions supporting the inclusion of a definition of reverse sensitivity because it does assist with plan interpretation. At this stage, due to the strong support for the current definition, I maintain my view that the definition is useful, and I will give further consideration to any amendments to address the concerns raised by Kāinga Ora. In our Section 42A report with respect to treaty settlement land, we signalled a willingness to explore the recommended definition further. We really appreciate the input and discussion that has been had today, provoked by Te Kahui o Taranaki and Te Kohitanga Te Atiawa, which has been really useful and aided with my understanding of the key issues as well. So both iwi have concerns that the definition of treaty settlement land is too narrow because it only applies to the deed of settlement or settlement legislation properties. The currently recommended definition would not apply to any Crown-owned land purchased by an iwi authority to achieve its aspirations and grow its asset base. TKO TAT is concerned that this approach continues to restrict and narrow how Māori land can be developed. Specifically, it goes against the intent of the strategic objective TWO11, which seeks to enable tangata whenua to protect, develop and use their ancestral whenua in a way which is consistent with their culture and traditions and their social, cultural and economic aspirations. TKO TAT seeks that relevant enabling provisions, such as the strategic objective TW011 and the definition of papakāinga, replace reference to treaty settlement land with the broader reference to iwi or hapu-owned land. Alternatively, if the term treaty settlement land is used, it should specifically include land owned by iwi through private purchase or acquisition. Te Kahui o Taranaki has echoed these sentiments. I acknowledge and understand the issues raised and agree in principle that the definition should be broadened in scope to achieve the strategic objectives and achieve the matter of importance 6E of the RMA. I will need time to consider the evidence presented and discuss these matters in consultation with Ms. Jo Ritchie, who is the author of the tangata whenua chapters of the proposed district plan. Our written right of reply will make a recommendation on this request, including the reconsideration of earlier recommendations with respect to the use of the term treaty settlement land within the strategic objectives and the definition of papakāinga. Moving on to rural character, federated farmers oppose the reference to network utilities within the definition of rural character and seek that specific reference to primary production is inserted. Federated Farmers notes that network utilities are often not present in rural areas, whereas the primary production is almost always located in rural areas. I stand by my initial recommendation with regard to network utilities. However, I do consider that the definition could be refined or improved as it relates to primary production activities. I will need some time to consider this matter in discussion with Ms. Young, who is the reporting officer for the rural zones, and will provide a recommendation in the written right of reply. With respect to natural water body, Federated Farmers has raised concerns about the definition of natural water body, seeking additional exclusions to ensure that artificial water bodies induced wetlands, and areas of improved pasture are not captured by the definition and associated rules. As requested by the panel, we will revisit earlier recommendations from hearing 5 on Federated Farmers' submission on natural water body, including consideration of scope for the changes sought. I looked up the Federated Farmers' original submission, which did make a submission on natural water body, seeking that constructed water bodies are excluded from the definition of natural water body. So Denise Young, who's the author of the 42A recommendations for water bodies, and I will give this matter some further thought. And as a result, if we decide to recommend any further changes to the definition of natural water body to address the concerns by Federated Farmers, we will seek the views of both Federated Farmers and iwi in our revised recommendations. We will also record the views of each of these parties in our written right of reply. So that concludes the matters I had in my verbal right of reply. Are there any other matters that the panel would like me to address in my written right of reply?
None from me. I think that's pretty comprehensive, Jamie. We'll see whether Antoine and Kit have any other notes they want to pick on.
I didn't really. I'm probably nitpicking now. Just if there was any further comments around Department of Corrections submission, just around the community corrections activity, community facilities, and the household. It was more of a minor point than anything. But if we had any further thoughts on that.
I think they were generally supportive of our 42A recommendations, so we'll be maintaining our 42A recommendations on those matters, unless there was something more specific you wanted me to investigate.
No, it was,
no.
That's fine.
Cool.
Looking at your notes, Kit, is there anything else springs to mind?
Nothing's leaping out at me. No. Thanks.
Okay, so short and sweet, Jamie. I think that's really good. There's a few things for you to check on, but really, you know, we're not looking at any substantial contest on any of these matters, from what I can see. That I'll stress again, anything around the wetlands and water bodies just have to be very careful with. Yes, it's an area of lots of discussion at the moment. So thank you for your assistance.
Sorry, Stephen. I knew there was something I wanted to just pick up on, because it, Jamie, you've recommended a new definition for public access corridor, and the proposed definition has a number of capitalized terms in it, like coastal walkways, Taranaki Traverse, shared pathways. Are they capitalized for a particular reason? Is that because they're separately defined terms?
Not separately defined for terms, so no, the answer is no. So they don't need to be capitalized.
All right. Okay, it was just, I think it's probably something we'll deal with right at the end in our sweep up. Just some things get capitalized and some things don't, when in reality, the thing that we can't see from the written version that we're all working on is that they'll have a hyperlink potentially if they're already defined somewhere else. So that was my only query. I just wanted to get a sense of whether there was any particular reason why, but you've said there's not. Thanks.
Thank you. And I just wanted to make a request, just because we do require input from third parties in terms of rounding out those definitions of natural water body and treaty settlement land. We will require some legal input from Lauren Wallace on that, no doubt. So just wanted to see whether the panel would be amenable to an extension just to the 23rd of May, so 15 working days from now, for the written right of reply.
Yeah, that's fine, Jamie. That's all good.
Thank you.
Thank you. And before we go to a karakia, just like to say a huge thank you to everyone again. It's been a good smooth hearing, lots of interesting discussion, even though Yeah, some of these topics on the face of them seem reasonably straightforward, but there's always something pops up that's of interest. So really do greatly appreciate everyone's attendance and participation. And Antoine, could you, on that note, just close our hearing?
Yeah, happy to. Just blowing my nose and things. I hope this is hay fever and not something else. Goodness me.
You've already had it.
Yeah, I know.
Put your mask on.
Yeah, I might have caught a virus on my computer. He mihi kawana kia koutou, o tira kia koutou ngā pautiaki o ngā iwi, ko tai mai nei I tēnei rā, ki te whakawhitiwhiti ngā kōrero pāna ki ngā kaupapa I mia tātou, no reira kānui ngā mihi, o tira kia koutou ngā apiha I roto I te kaunihera o ngā motu, he mihi kawana, he mihi kawana, he mihi kawana. Ai tukuna atu ngā mihi ki tā tātou kaihanga, nāna nei te tīmatanga, a nāna nei te whakaotinga mea katoa, no reira whai korori a hareruia kia ihoa ngā mano mātua tama wairua tapu mena pono me te māngai, a tātou ki te kauri, ki wairua te arapa te amika poriori tua hāmura te tīmatanga me te whakotinga mātua tumatu nei, a ko te māngai no hei tūtuku mai ai ni akane āmane. Kia ora whānau.
Kia ora, thank you. Bye-bye, everyone.
Kia ora, thank you. Bye.
Bye-bye.
See you later. Thank you.